Hey. Oh. Good morning. Oh, she mad too, huh? Okay, well. What? No, we did the all right. Everybody was good. We took care of it. Okay, and staff, what have we learned? This is what occurs when you leave me alone. Okay, I spoke to this before. The party is where I am. Why are you shaking your head? What was it? It is so hard being me. I'm going to get lectured today. Okay. I'm going to stay out here all the time. That way I don't have to hear it. Court does call the case of the people versus Angela Stoker.
When you get your honor, bring cook for the people.
Brianna Bradley for the piece.
Ron Brown praying on behalf of the Stoker.
Your name?
Angela Stoker.
I have before me a plea form that indicates that the defendant will be pleading no contest to the charge of disturbing the peace, 90-day offense. Upon a successful plea to that charge, count one would be dismissed. Did Cook write this? They're also agreeing to prosecutors deferred no upfront jail. I got it.
Happens when I write them jail.
No, it's okay. I'm learning to read your writing.
That makes one of us.
All right. That's the court's full understanding.
Yes, you are. That's right.
All right. May I have her sworn?
I'm sworn to affirm the testimony you're about to give will be truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Angela Stoker.
Stoker, it's this court's understanding that you're going to be pleading no contest to the charge of disturbing the peace. That is a 90-day misdemeanor punishable by the 90 days and up to $500 fine plus court costs. Do you understand that? Do you understand what a no contest plea is?
Yes.
Two things about it I have to make sure that you understand. The first thing I need to have you understand is it means that you're not further desirous or wanting to contest this charge. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Okay.
You understand that? All right. Basis for the no contest plea.
Potential civil liability.
So, ma'am, to that charge, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct? Any question about any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving those rights as well as all the rights on it.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated today to get you to?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily
Yes.
and of your own free will?
Yes.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 25-12323. Any objections to the court having reviewed this?
None from the people. No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, I do have to advise you, if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people. No, Your Honor.
And have I complied with the court?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea of no contest. Count 2, count 1 is dismissed. Defendant is referred probation for pre-sentence investigation and report and consideration of the prosecutor's deferred. Sentencing in this matter will be
May 13th at 9 a.m.
May 13th. Is that okay?
Yeah, yes,
Is there a problem with that day?
no,
When we-
I have to
Well-
work later that day, but
Pardon?
I just have to work later that day.
What time do you work? 2. And what time is this?
9 a.m. You
You start working at 2.
Yes,
We'll have you at it.
okay.
Sentencing May 13th, 2026. Bond will continue. Can we make a note to try to put her in the early block? All right. Well, you get here, we'll get your sentence to get you. All right.
Okay.
Thank you. Thank you.
Thanks.
This has been a pleasure. See, when I do this myself, no. You just said, why are you shaking your head? What did I do that is wrong? I came in, we did an efficient docket. The one case, where was I? Where? Okay,
At all. To the charge impeding traffic, do you plead responsible or not responsible?
Responsible.
Are you in school still or are you out?
No, Your Honor.
I don't know. No, what? No, you're not.
No, I'm not in school, Your Honor.
Pardon?
No, I am not in school, Your Honor.
Did you graduate?
Yes, I did, Your Honor.
What are you doing now?
Security, Your Honor.
Security where?
In Wyandotte.
What that means in Wyandotte. Where does that, where at in Wyandotte?
At BASF.
Clerk.
Listen, I'm going to take your plea. I'm going to dismiss the traffic control device. I'm going to dismiss the violation basic speed law. I'll tell you, you got to be more careful here. 195 is your total. Can you pay that?
Presented by Mr. Ocello. We have Mr. View from the prosecutor's office. We're here today for a pretrial. It's my understanding Ms. Wells is going to be entering a plea of guilty to 1 count of illegal conveyance. We're set this for sentencing. Is that accurately stated?
Yes, Your Honor.
Ms. Wells, how old are you?
24.
How far did you go in school?
I'm actually in college right now. I'm in nursing school.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
I take Prozac.
You're taking anything that would interfere with your ability to understand what we're doing here today?
No, sir.
Are you a United States citizen?
Yes.
We've had some discussions about your case, Ms. Wells. If you enter a plea of guilty to this charge, I'm not going to sentence you today because I don't know enough about you and I don't know enough about this case yet. What I'm going to do is conduct a level 2 pre-sentence investigation and we're going to come back for sentencing. I've told your attorney that this is the kind of case that I will probably put you into my community control program with no additional jail. I have a lot of people that bring drugs into the facilities. I have a jail, community-based corrections facility, and 2 prisons in my jurisdiction. So I see these cases a lot. Ms. Wells, candidly, I used to send everybody who was involved in bringing drugs into the prison to jail for 90 days. What I found, though, was it wasn't particularly effective because most of the people that I have on my docket who do this kind of thing, it's the dumbest thing that they ever did in their life, and they will never do it again, and they perform well on probation. Some of my folks are not like that. They want to continue to try to make money doing this or whatever. Those people end up going to prison. But for most of my folks, it's just something stupid that they got drawn in by somebody that they shouldn't have an association with. And it goes from there. So with that in mind, other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, Your Honor.
I have a document entitled Change of Plea and Entry. On the second page, there is a signature above the line defendant. Is that your signature?
Yep.
Did you review this with Mr. Ocello before you signed it?
I did.
Are you satisfied with the representation that you have received in the case?
I am.
You're going to enter a plea of guilty to one count of illegal conveyance of drugs of abuse onto the grounds of a specified government facility. This is a third-degree felony. It's punishable by up to 36 months in prison and a $10,000 fine. If you violate the terms of your supervision and I do have to send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, Your Honor.
Mr. View, what are the facts?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on January the 15th of 2026 at Lebanon Correctional Institution, a detention facility located in Warren County, state of Ohio, the defendant did convey methamphetamine to inmate El Rashawn Dover.
Anything on those facts, Mr. Ocello?
No, Your Honor. Thank you.
Ms. Wells, did you hear those facts?
Yes.
Do you admit they are true?
Yes,
Do you understand the rights you're giving up by entering a plea?
I do.
What's your plea? Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm not going to go into the matter of the sentence today. Instead, you're going to go back down to pretrial services. You're going to fill out the paperwork for the PSI. We'll see everybody back here in about 6 to 8 weeks. Okay?
Thank you. Thank you.
State of Ohio versus Tiara Spencer, case number 26 CR 43369. Present before the court is Ms. Spencer, right?
Yes.
Represented by Mr. Aldridge. We have Mr. View from the prosecutor's office. We are here today, Ms. Spencer, for a pretrial, but it's my understanding that you're going to be entering a plea of guilty to one count of legal illegal conveyance. Is that accurately stated?
Yes.
How old are you, Ms. Spencer?
I'm 26.
How far did you go in school?
I graduated high school.
Are you able to read and write English?
Yes, I can.
Are you under the influence of drugs or alcohol?
Huh?
Are you under the influence
no,
of
I
drugs
don't
or
smoke or
alcohol?
drink.
Are you taking any medications?
No.
Are you a United States citizen?
Yes.
We've had some discussions about your case. If you enter a plea of guilty to this charge, I'm going to do a level 2 pre-sentence investigation and come back here in about 6 to 8 weeks. You heard what I told Ms. Wells about these kinds of cases. Normally, I put people into my community control program on straight probation. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No.
I have a document entitled Change of Plea and Entry. On the second page, there's a signature above the line defendant. Is that your signature?
Yes.
Did you review this with Mr. Aldridge before you signed it?
Yes, I did.
Are you satisfied with the representation you've received in the case?
Yes, I am.
You're going to enter a plea of guilty to one count of the illegal conveyance of drugs of abuse onto the grounds of a specified government facility. This is a third-degree felony. It's punishable by up to 36 months in prison and a $10,000 fine. Also carries with it an optional period of post-release control of up to 2 years. Before I go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. You have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at that trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes.
Mr. View, what are the facts?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on January 30th of 2026 at Lebanon Correctional Institution, a detention facility located in Warren County, state of Ohio, the defendant did convey Suboxone buprenorphine to inmate Desmond Harris.
Anything on those facts, Mr. Aldridge?
Note that this was an attempt, it was not a successful conveyance.
Well, she successfully conveyed it onto the grounds of the
But
prison.
not to that inmate.
Well, she conveyed it onto the grounds of the prison with the intent to deliver it.
Yes.
To inmate Desmond Harris.
That's
Okay.
correct.
With that clarification, anything else on the facts? Ms. Spencer, did you hear those facts?
Yes,
Do you admit that they are true?
yes,
Do you understand the right you're giving up by entering a plea?
yes,
Which plea?
guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. We're not going to go into the matter of the sentence today. Instead, we're going to do a level 2 pre-sentence investigation, and we're going to come back here for sentencing. That's going to take place probably in about 8 weeks. Are we going to pass our drug test today?
Yes.
All right, you need to go back down to pretrial services, fill out the paperwork for the PSI.
Okay, thank you.
All right.
There.
That today,
Yes, Your Honor.
please slow down, running 4 stop signs in a subdivision. Kids running around there. This was at what time?
I believe-
1:41 in the morning. How old are you again, Mr. Barton? You say 19?
Yes, Your Honor.
Nothing good happens at 2:00 in the morning. Thanks, Mr. McDermott. Have a good day. Good luck.
Thanks, Judge. Take care.
You're gonna pay that today, right, sir?
Yes, Your Honor.
All right, good luck. All right, people against, Agron Brahheim, 267842174. How you doing, Ms. Garion?
Good, Judge. Good to see you.
You too. Everybody, what do we owe the pleasure of you coming in person?
I was told to come in person, so I followed directions. I don't know why. I'm special. Oh, here I am.
Why did they tell you to come in person?
I don't know. And I even called.
Who'd you talk to?
The court notice says in person, and then I called, earlier this week.
Heather, do you know anything about that?
I do not, Judge. I'm looking at what case it is. Usually we put in person on the defendant's copy, but then if there's, oh no, and on these I usually, oh no, she's a pre-form. I usually send a Zoom form with these for the pre-formals with the retained attorney.
Yeah, what happened here? Well, I don't know what happened.
I'm here and it worked out and it's fine, Judge. Always good to see you.
You too. I don't think you would have talked to my judicial clerk because I don't think she would have insisted that. I know she wouldn't have. Maybe you talked to one of the other staff and they thought you were a defendant. I don't know. But at any rate, my apologies. You're gonna plead to impeding your authorized signer of that plea, correct? On behalf of your client?
That's correct.
To that charge, responsible or not responsible?
Responsible.
Plea is accepted, 150. I'll give them a week, okay?
Perfect. Thank you.
May 6th. Have a great day.
Too.
Take care. Be careful out there. All that water on the road with, right? Herren. Justin Tyreek Herren. 26W8417883A, B, and C. Okay, Mr. Herren, you can come on up here and tell me your name, please.
Justin Herren.
All right, so you met with the city attorney. You're going to plead guilty to allowing an unlicensed driver to drive. And they are then going to dismiss the They are then going to move to dismiss the driving on a suspended, no proof of insurance, and expired plate. True?
Correct, Your Honor.
And that's what you want to do?
Yes, Your
And
Honor.
apparently you have another ticket you're going to pay today, right?
I'm on a payment plan. I just made a payment for the.
All right. Okay, if you plead guilty to allowing an unlicensed driver to drive, I'm going to dismiss all other charges. The possible penalties are up to 500 fines, 90 days jail. Costs are all those. Do you understand that?
Yes, sir.
You just sign, read, and understand the advice of rights.
Yes, Your
You
Honor.
plead guilty, you'll be giving up all those rights, and we're not going to have a trial. Do you understand that?
Yes, Your Honor.
You still have the right to a lawyer. If you want one, I'll give you one. Do you understand that?
Yes.
Would you like a lawyer?
No, thank you, Your Honor.
To the charge allowing an unlicensed driver to drive, how do you plead?
Guilty.
On the 7th of March of 26, were you in control of a 2011 Ford that was being operated on Western Island and Woodhaven?
Yes, Your
You
Honor.
allow somebody to drive that was unlicensed,
Yes.
and that was you, right?
Yes.
Are you on probation or parole?
No,
Anybody force you to plead guilty?
no,
And you're still suspended, right?
yeah,
Please accept it. The suspends, dismissed, no proof of insurance, and expired plate are dismissed. You got to stop doing this, son. Anything you want to say?
no, Your Honor.
100 fines, 150 costs, 75 victims' rights, $50 justice assessment. I'll go kind of light, but 375 or 90 days. Do you have all that to pay
375.
or 90 days?
I can start. I got a payment plan on the 272 for those victims. So can I put them together for a payment plan?
When are you supposed to pay and how much on
I
those?
just paid today. Another payment. Supposed to pay 55 a month.
Yeah, Judge, his payment plan on his other tickets is $55 monthly. He did make a payment today on that.
I low operator.
How much do you make there?
Maybe 18 bucks. 18 bucks.
You have kids?
Yes,
How many?
one, but I take care of everything in my household.
So you can pay that, can you pay 50 more per month on this one?
So 100 a month total.
Well, if you're paying 55, yeah, that'd be 105. Can you do that?
I can make that happen.
All right, 50 per month, beginning May the 15th. Can you do that?
Yes, Your Honor.
Or you want me to give you a little more time? How about May 31?
End of May.
May 31.
Yes, sure.
Okay, you're all set.
All right, thank you.
Have a good day. It'll give you another printout on that just so you know you have to pay on that particular case. So go down the hall, please. Austin J. Doyle, 26W8419318. Did you send that other file down with John yet, Heather?
No, I have it sitting here. He hasn't been down here.
Okay, okay. Your name?
Awesome, Doyle.
All right, you're charged with driving on a suspended. I can arraign you, send you to the prosecutor, or I can give you a lawyer.
Give me a lawyer, please.
Sure. I'll give you a lawyer. Then you have a second charge of obstructed vision. Heather, can you have somebody run that down, please?
Yes, Judge, I have someone bringing it down right now.
Go out there. He's going to set you up with a lawyer. You can go right outside in the hallway, okay?
Thank you, Your Honor.
Thank you. N.A. Manson Sons Inc., 26W842464. That needs a lawyer. And this one's done. Your name, sir?
Eric Conley.
And I can't let you appear on behalf of a corporation on a misdemeanor. I'm sorry. You're going to have to get a lawyer. I'm not trying to make money for lawyers, but that's just the rule on a criminal case. So I can't do it. I can give you an adjournment, but you're going to have to hire a lawyer, okay?
Sir.
It's not my rule. It's the state's rule. The court's rule, whatever you want to call it. Mark, May the 13th. Is that at 8:30, Heather?
Yes, we could do 8:30.
I'm sorry. It's your first name is
Eric.
Eric. And that's TR1BLEY, right?
Yes.
Thank you.
Okay.
You're all set. Thanks. Mr. Knight, you and I are going to talk.
I know, Judge.
I'm not happy.
Not.
Eric Tarenti Bagaya, Jr., 26F262289. Your appearance?
Oh, Judge, Patrick Reynolds, P76.
Oh, this is the one.
Tomorrow.
Yeah, I know. This is the one. I want you up here. your appearance.
Contract 99 P76343. Sorry, Judge, I was very confused.
Well, I called it because I got the stipulated order adjourning bench trial.
Correct.
I had told you last time I was not going to adjourn the trial.
I understand.
Why in the world would you do that and submit that with the hopes it's going to get by a judge? Either that or you thought I was kidding.
No, Judge.
I don't kid in here. I have a very good sense of humor outside of here, but I told you I wasn't going to adjourn this. And then I get a stipulated order, like I sign 150 to 200 orders a week, probably in judgments. Why would you submit an order, a stipulated order adjourning a bench trial when I just got done telling you I wasn't going to adjourn it? I hope you don't do that in other courts.
Judge.
So listen to what I'm telling you, counsel. I am not happy about this. I don't fool around in here. I'm not kidding. You guys had multiple pretrials. And now all of a sudden there's this urgency to adjourn because your client is going to start a job. If you had a pretrial on February the 5th, 19th, 16th of April, February 5th and 19th and March 19th and April 16th. And now you're telling my clerk your client's not showing up and you want to know when you can walk them in? Listen to me very carefully. If he dares plays games with me like that, he better have a lot of money. And don't think if you walk in here on Monday or Tuesday or Friday that I'm going to just say, oh, let's let bygones be bygones. He will be sitting in that lockup unless he's married to a physician for the longest time. But more important, I'm disappointed in you. When I tell you I'm not going to adjourn something, you don't submit a stipend order to adjourn behind my back with the hopes I'll forget about it and sign it. I'm serious as a heart attack. Why would you do such a thing?
Mr. Bogia asked me if I could do whatever I could to get it.
You brought it up. I said no. Why would you do such a thing? I don't care what your client asks you to do.
Judge, he finally got it before. He has 2 weeks where he can't.
This is an animal violation case. It's a dog bite.
It's a domestic violence charge. And they're going through a custody issue, so that's why we were trying to get it so the custody issue would not affect his.
You mean to tell me if he starts one day later, he can't get a job at Ford Motor Company?
Judge, the email said that he has to be there for 2 weeks straight. Otherwise, he will be terminated from the job. There's no exceptions, no excuses.
When is he supposed to start?
He started on Monday, Judge. So I think he's gonna miss work tomorrow and have to reapply to Ford.
Listen. I thought it was an animal violation, but it doesn't matter.
Now, did you?
Well, why so many? This is a domestic violence case. That's fine. But why so many pre-trials? If you guys needed to push this through, I'd have given you a trial date 6 weeks ago.
Judge, we didn't want to push this through. We wanted to work with the family law to get their custody issue set up at the same time as this was being resolved. And they were supposed to have a custody hearing last week, and it's been a contentious issue. So, and he wants to be able to support his 2 children with the victim. He was a former police officer.
I don't care who he was.
And he lost his job, and now he's been working as a plumber, but he's like, I finally have a job to get in at Ford. I can't leave my kids and move some other place.
I know, but if he told you that.
Judge, I begged him to set it. I said, can you start 2 weeks later?
Listen to me. If he told you that. I vaguely remember you saying something about starting a job. Maybe you brought this up.
I don't believe I did, Judge, because I didn't know. He said he was looking for a job. He was waiting out for to get back to it, but I don't know if I brought that up. I did bring up the custody. I wasn't trying to sneak anything by the judge.
No, but you can't do this. I was really surprised. I didn't think you would do something like this. I mean,
Well,
well, you could have filed an emergency motion then and it been explanatory. It said this, that, and the other. All I've heard is adjourn on this case. I don't want to cost anybody a job. Heather, I'm going to forget that Mr. Nienhouse handled this inappropriately.
Judge, I take full responsibility.
Hang on. I'm going to adjourn this. You called Mr. Cayley's office. They already submitted a stip in order. I'm going to adjourn this 2 more weeks. Is that going to do it? May 14th?
Yes, Judge.
You sure?
Yes, Judge.
Because you said he started this last week and he needs to be there for 2 weeks, right?
He told me it was 2 weeks. He can't, I was like,
All right. Okay, fair enough. For some reason, I thought this was an animal violation.
no, Judge, this was a,
We're going to adjourn this to, or is it May the 13th, Heather? No, May the
No,
14th.
it'll be May 14th, Judge. Do you want to
And
do
I'm here
it
that
at
day,
11
right?
o'clock? Yes, you are.
What time are we going to do this?
Do you want to do
Yeah.
11? Are we doing it as a trial that day?
Yes.
So you want
What?
to do 11 o'clock?
What?
I was gonna say, I have a dearborn at 8:30 in the morning, so if I could just have it after 9:30 or 10.
I'll make it 11. May 14th at 11. I'm going to forget this happened, by the way. Next time, file a motion, emergency motion. I'll accommodate you with an emergency motion, but I felt like you were trying to get one by on me. And I don't like that.
No, Judge, as soon as I got information from Mr. Bogia, I reached out to Mr. EPA,
May 14th. That's what we'll do.
and I was like, I told him what's going on. I was like,
All right, good enough. Good enough. No sense groveling any further, but I was disappointed in you. That's all I'm going to tell you. It's forgotten. People against Bradley. Brianna May Bradley, 267-841-845, A and B. Now, what is the situation with this? Ma'am, come on up here and state your name, please.
I'm Brianna May Bradley.
So the prosecutor's just dismissing. Is there a reason for it?
Yes, Judge, we found out later on there were co-defendants after I filed my appearances because they just got 2 separate tickets. The co-defendants taking full responsibility for this, and Miss Bradley was, based on the video evidence, was trying to break up the incident.
Okay, so for purposes of arraignment, she stands mute with
Yes.
formal reading. Dismissed motion of the prosecutor.
No.
So he's saying that he's going to go ahead and just, because the co-defendant, Mr. Bradley, is going to take responsibility, right?
Yes.
Okay, good enough. Case dismissed, Nolly Prost, motion of the prosecutor. Ma'am, he is dismissing without prejudice. I'm not saying he's,
Hearing? Yeah, he does not. He's prepared to admit to the violation to special conditions of 15D and 15E.
All right, Mr. O'Connell, you understand you're entitled to have a hearing?
Yes, Your Honor.
You wish to waive that hearing and admit to the violation?
Yes, Your Honor.
All right, the court's going to find that you have violated the terms of your ILC. At this time, based upon the recommendation of your new ILC officer, the court's going to continue you on ILC despite this violation. You got to pay the restitution.
Yes, Your Honor.
You got to make the victim whole. I mean, I don't care if you go get a loan and pay the loan back, but you got to make the victim whole. Regular on-time payments is the only way to do it. Okay. You're not going to come to the end of the ILC and all of a sudden you still owe $20,000. It's not going to work that way. Okay. Stay engaged in the treatment that you started. Follow Officer Wilkinson's recommendations. Okay.
Yes, Your Honor.
All right. That's all.
Thank you, Your Honor.
he can't refile, but he's not likely to. So I'm dismissing your case. You're all set. Have a good day. Thank you. People against Christopher Bradley. Christopher Brian Bradley, Jr., 267-841-844 A and B. Make sure you call Mr. Cayley so he can call off his witnesses on that case tomorrow. Will you please, Heather?
Okay.
No, man. You can call him too. That's fine. All right. Your appearance,
Patrick Mann, P76343, Judge.
sir, your name?
Christopher Bradley.
All right. So we have a disturb the peace in an A and B. And does he stand mute and waive formal reading?
Yes, Judge.
And so now he's going to plead guilty to both of these, both the A and B and the disorderly under section 771.1. I got to call in the prosecutor real quick. Mr. Urick, please. I can't do a 771 for 18 months.
Okay.
It has to be disposed of within 12 months. FIDA you can, 769 you can, 7411 you can, any of these other statutes, but you can't do it on a 771. So he's just going to have to change it or do something else, but I can't do 18 months probation on it.
I should have thought that. So
That's all right.
I know sometimes you can waive that.
That's all right. Well, I don't.
Yeah, no, I.
Okay, so, sir, do you understand? So first of all, he stands mute, waives formal
Yes,
reading,
sir.
right?
Yes.
And now he's going to plead guilty to these two charges, disturb the peace in A and B, and then there's going to be a plea to, Urick, your name?
Good morning, Your Honor. William Urick on behalf of the city of Winnebago.
I can't do 771.1 for more than 12 months.
Is that right, Judge?
Yeah,
I apologize.
there's nothing to apologize about. You want to just redo it to 12 months or you want to do something else with Mr. Nyans?
Do it 12 months of the work, please.
All right, good enough. So it's going to be 12 months and that's still agreeable, obviously, with your client, right? Mr.
Yes, sir.
So if you plead guilty to that, sir, I want you to understand that each of these are punishable by up to 500 fines, 90 days jail, costs, or all those. I'll take them under section 771.1. The conviction will enter now. I'll send you for a pre-sentence report. And if you're compliant at the end of the year, the case will be dismissed. Do you understand that?
Yes, sir.
And you just sign, read, and understand the advice of rights. If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that? Okay. Do you have any questions on any of your rights?
No.
To the charge, disturb the peace, how do you plead?
Plead guilty.
To the charge, assault and battery, how do you plead?
Plead guilty, Your Honor.
On March 15 of 26 at 1:44 PM, were you at 22900 Allen Road near Weston Woodhaven?
Yes, sir.
Yeah. And what, is that a business establishment?
Yes, it is, Judge.
What is it? What business is that?
It's outside of Christoph's, Your Honor.
Okay. And what happened that makes you guilty of those two offenses? Disturb the peace and assault and battery?
Mutual combat, Your Honor. No. Well, so let me.
No, I mean,
Can I?
no, let me ask the questions. Did you come into contact with Joseph Clinton?
Yes, Your Honor.
Did you know Joseph Clinton prior to that? Did you just meet him that day?
That was our first meeting, Your Honor.
Okay. And what happened? Did you strike him in any way?
I did strike him, yes.
With what?
My hand.
This? Okay. Where'd you strike him in?
Space, Your Honor.
How many times?
Unknown amount, Your Honor.
Pardon?
Unknown amount, Your Honor.
So you punched him in the face multiple times. Is that fair?
Yes, Your Honor.
And were you disturbing the peace in some other way? Were you yelling, screaming, swearing?
Other people got out of their cars and it caused the disturbance. Yes, Your Honor.
Okay. So what happened? Why did you punch him?
He almost T-boned me and my children, Your Honor.
All right. So he was backing out of a car, out of a parking lot?
No,
Or?
it was at the intersection, Your Honor.
Okay. So you got angry with the way he was driving. Is that fair?
Yes, Your Honor.
And then you accosted him or came up to him and started yelling at him. Is that fair?
Yes, Your Honor.
And then what happened? Did he ever punch you or swing at you or take a strike at you before you punched him?
Before, no, Your Honor.
Not before.
Before, no, Your Honor.
So you were the aggressor first. Is that fair to say?
Yes, Your
And
Honor.
that you weren't acting in self-defense?
No, Your Honor.
Are you on probation or parole right now?
No, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
You're satisfied, right?
Yes, Judge. Thank you very much. I appreciate that.
I'll accept the plea. I'll take it under 771, both of them. And I'll make them 12 months. And we'll set it under, I'll take it under 771.1 commencing on the date of the sentence. I am going to order, he wasn't under the influence of anything, was he? You agree this wasn't the right way to handle this, right?
Big mistake.
Okay, fair enough.
Told you, you're gonna take responsibility.
I got it. Mr. Nanhouse, I'm gonna give him 3-sentence report. If you want, maybe I can even do it the same day as your other case. We set it for May 14th, right, Heather?
Yes, at 11 a.m.
Yes, Judge.
Well, let's set this one for 10:45. How's that?
Perfect, Judge.
And then I'll set some in. And getting back to the other Mr. Nanos, maybe it was just a misunderstanding. I'm gonna give you the benefit of the doubt. And I was just upset when I got a stipend order to adjourn when I'd said I hadn't. And next time I just encourage you to file a motion and explain it, and I'll be reasonable with you, okay?
Okay, please, Judge, I appreciate you.
All right, so you're gonna go down, no problem. You're gonna go down the hall. And just to not carry on here, I've always liked you, so you're gonna go down the hall, get your notice, and then you're going over to probation where you'll be interviewed, okay?
Judge, I do have a question. Can we do
Sure.
it that day, or are we gonna notify the victim on this, or no?
You have to notify the victim.
So does it have to
probation-
be on a Woodhaven day or no? If we have to notify the victim?
Yeah, it should be. That's Woodhaven though, right?
Not on that other day as his other case, because that's a Thursday.
Because that's a flat rock case, Judge.
Oh, jeez.
Judge,
Yeah,
I'll make
so we would,
Okay, yeah.
we have
we're
to
gonna
do it on
make
the 13th.
My mistake.
No problem, Judge, 13.
Yeah,
And Judge, are both of these being taken under 7711?
both of them will. Yes.
Okay, thank you.
So we'll make it May the 13th then. Are you good at 8:30 or?
Can we get a little later, so they don't go.
I don't have a problem. I'll make it 10:30. How's that?
That works, Judge, thank you.
Okay.
Here a little early.
I gotta set bond conditions though. I neglected to do that. Your client doesn't have any warrants out, does he?
No, Judge.
He was never fingerprinted on this though, was he?
No, he was not, Judge.
So, sir, listen, I have to order you to go over there and get prints, okay? So here are your bond conditions. I'm gonna give you $1,000 personal bond, okay? $1,000 personal bond on these. And we'll give you a copy of the bond sheet. You cannot leave the state without the consent of the court or violate any law or ordinance. You must appear in court as directed, okay? And I'm going to go ahead and order that you go over to the Woodhaven Police Department to be fingerprinted and photographed by 1 p.m. today, that you not purchase, possess, or possess firearms or other dangerous weapons, that you not enter the property address at 22900 Allen Road. That's the Christophs. And also that you not have any contact with the victim, Joseph Clinton, okay? So you cannot have any contact with him. You cannot have anybody write him, phone him, see him, text him, email him. You cannot do any of those things for you or on your behalf. You have anybody else do any of those things for you or on your behalf. Do you understand that?
Yes, sir.
And I'm gonna fill out an order for prints, which they're gonna send over there. So you have to go over to Woodhaven today and we will go from there. Anything else, counsel?
No, Judge, we're gonna leave it to appearance, and you'll split for probation, and then we should be done by once, we can get to it.
Absolutely. Thanks a lot. Have a good day.
Thank you, Judge.
Thank you. All right. Okay, there we go. All right. Tamara Hall. This is 2-6-8-4-1-8-4-6. Good morning, ma'am. Your name?
Tamara.
Did I get you a lawyer?
You did.
Where is he?
And with all of us.
I don't even see where a stip form was done. Did he meet with the prosecutor?
You did, yes.
John, see if I accidentally put it in that file. I might have accidentally put it in that last file. I don't see one in here. Well, maybe I did pull it out. That's my guess.
Yep.
Wow. Okay. All right. Let me go on to the next case. Why don't you have a seat right there? McLilly Wilson, Jordan Elizabeth McLilly Wilson, if that's you, ma'am, 26W842 3808 and B. Come on up to the podium and tell me your name.
My name is Jordan Bowie Wilson.
You're charged with operating while intoxicated. You're also charged with minor in possession. You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
Yes, please.
Okay. We'll give you a lawyer. You go out in the hallway and we'll set you up, okay? Good luck. Recalling Tamara Hall, 26W841846. Good morning, ma'am. Your name?
That's Tamara Hall.
Mr. Crawford?
Morning, I'm Mike Crawford, representing Ms. Hall.
So she stands mute, waives formal reading, right?
That's correct.
He says you pre-tried it. He says extenuating circumstances, so he's going to dismiss the B&E or mitigating circumstances. He's going to dismiss the B&E and have her plead to a civil infraction, public nuisance, right?
That's correct, Your Honor.
To that charge, ma'am, of public nuisance under 110-106 of the Woodhaven Code of Ordinances. How do you plead responsible and not responsible? Please accept that B&E is dismissed, $200. You can go down and pay that. You're all set. Best of luck to you.
Yeah.
Good luck.
To the end of the day.
You don't have it now?
I have it. I have $20.
Okay. Yeah. Okay, you can go down the hall and take care of that. We're setting you up with this one too, John. Give him that one.
Oh, is that Crawford? Here you go.
I mean, it's a docket case. I don't know if he's on our docket. Well, there you go. All right. Do we have anything else that's here ready to? I mean, we don't have any cases after 10:15, do we? Except for sobriety court this morning and.
We do have the one case, we have the clients here for
Mr. Gates,
Mazin. We're waiting on Mr. Gate, and the interpreter called me. He's stuck at the train. So we're waiting
Okay.
for him.
All right, no problem. Thanks.
Yeah.
Ignoring me completely. Sorry, Jeff. It's not your fault. Leonard Keelan.
Hey, Judge, good morning, good morning, good morning. Hey,
Hey,
this case,
hey.
good morning, good morning, good morning.
Hey. What the hey?
Good morning, good morning.
Where is it?
If you get called, Mr. Elam.
Where'd he go?
Elam.
There he is. Dr. Eden?
He might be a doctor. So to give you the quick up to speed on this one, Judge,
I did ask for discovery, got discovery from Ms. Gasper. She sent me an email back saying that Mr. Paget was going to be hired on the case that I got.
All right, Mr. Caldwell, good morning.
Morning, Your Honor. So we're gonna be at Caldwell on Mr. Doyle, the stage, am I right?
Sir, your name?
Don Doyle.
So this is gonna be a plea to what?
We have an agreement to a disorderly person and a civil nuisance. The other two can also be dismissed.
So he's gonna plead the disorderly person on the larceny, is that it? That's
Correct.
and then he's going to plead the public nuisance. Public nuisance on the B file, which is the concealed property file, right? Am I reading this right?
That's correct.
All right, and that's a civil infraction. So you understand what has just been said here, Mr. Pitaway?
Yeah.
All right, so if you plead to public nuisance, that's a civil infraction. If you plead to disorderly person, that is a misdemeanor punishable by up to 500 fines, 90 days jail costs, or all of those. Do you understand that?
Yes.
And you just sign, read, and understand the advice of rights.
Yes.
If you plead guilty, you'll be giving up all those rights, and we are not going to have a trial. Do you understand that?
Yes.
All right. To the charged disorderly person, how do you plead?
Guilty.
On March 31 of 26 at 7:03 p.m., we had 23901 Allen Road near Weston Woodhaven.
Correct.
What business was that?
Tire shop.
Which one?
Bell Tire.
And what did you do?
I went back there, caused a disturbance.
Nah. Did you take 4 tires totaling $80, total value $880, attempting to sell them? So you stole $880 worth of tires, is that true?
Yes.
Are you on probation or parole?
Yes.
Anybody force you to plead guilty?
No.
They should have charged you with a 1-year misdemeanor, you know that? Yeah, these disorderlies, they drive me crazy. Disorderly person. What? I got guys trying to tell me I was loud. To the charge public nuisance, how do you plead? Responsible or not responsible?
Responsible.
Please accepted to that. It's a civil infraction. Please accept a disorderly. The larceny is dismissed. Concealing stolen property is dismissed. I'm still ordering a pre-sentence report, okay? So we'll come back for sentence. It's going to be May the 13th, Heather.
Yes, Judge.
And we'll do that at 8:45. Is that good, Mr. Caldwell?
Yes. May, what day?
That's 2 weeks from today, May the
May
13th.
In the morning. Yep, that'll work.
All right, good. Okay. Bonds continued. Mr. Pitaway, you're going to go down the hall, get your notice, and then go over to probation where you'll be interviewed. All right. We'll see you back here. Thank you.
Thank you, Doc.
You have a good day.
You too, thanks.
Is Mr. Gaith ready on his, Heather?
He walked away down the hall. He came down here and filed his appearances, so I'm not sure if he spoke with anyone yet.
And the interpreter's here.
Yes, I believe so. Judge, with that public nuisance on this one, you just want me to put this it with the sentencing on the 13th?
Correct.
Okay, thank you.
So the last two are Woodhaven cases, right? Mr. Gase and
Yeah.
Mr.
When Crawford has Stiller and Hicks.
We still got all those?
Then Mr. Granada and Mr. Doyle.
What in the world is going on?
I only need one of Granada, so I don't know what's going on.
What time did you give it to him?
Almost an hour ago.
Find out what's going on.
That's McLily.
Who?
McLily.
Tell me right now.
Did they want an attorney?
Who?
Oh, I must have been out of court for that. McLily?
Was that the driving unsuspended?
It was a open intox MIP thing for.
Drunk driving too.
Did she want an attorney or?
Yeah.
Yeah, I must have been out of the courtroom. You must have thrown it up and I didn't take a quick stack.
That's what. Hey, how are you, Judge?
When she responded to me, I contacted Mr. Paget, and as of right now, Mr. Elam hasn't paid Mr. Paget for that burglary case. And I think he's gonna hire Mr. Paget. And that's what he told me. When you sell it to the judge, so he'll know.
Yes, sir. What are you gonna do that this year, 10 years, next year? We move forward. I mean, we're not gonna wait on you for your finances. We're moving forward here. Hold on.
So just I was asked them to give him our assets.
I know you're not pleading you tonight. Here's the file. Here's the file.
No.
Usually when other
But I am appointed on the burglary habitation, which is this case, but that's the one that.
Okay.
He's gonna hire Mr. Paget.
All right. Today's case is a burglary of a habitation.
Right, but yes.
But he has
And-
two cases on the docket. They're just not listed together because Mr. Paget is on the other.
But
He has a burglary of a habitation and a theft of a firearm.
I did speak with him yesterday, Judge, and like I say, to my understanding, he hasn't paid him for the burglary case.
well, nonetheless, he announced he's a lawyer in the case. I mean, that's kind of an ethical importance. I mean, that's what we live on, right? If a lawyer's word, a lawyer's come up and says he's represented and it's on the record. So the finances are another thing. That's between you and him. That's not, I don't get involved in that. That's y'all's deal. Right now, the deal I have is that he's the lawyer of record. He should be here right now. Please call him.
There is not a
And-
letter of representation in the burglary of the habitation yet. He is representing him on the record in the theft of a firearm.
That's what I rely on for documents. I know, I'm saying 25-1056 is a case on that man's name. And we're gonna keep them together. We're not gonna put them in installments. You got the burglary. And that's that, but. The other case is set for an announcement Mr. Pageant was the attorney of record, so period, he needs to be here. Yeah, I'm gonna ask my staff to get him up here. I mean, that's just the way his police calls. It's actually James Pageant's office, police, thanks, and tell him you need him up here on Mr. Elam's case. Hey, what are you going to do?
With mine, Judge, since Patrick hasn't been officially hired, I'm just gonna represent him. So and then when Mr. Patrick gets on the case, then I'll get off. But as of right now, I'm gonna put all of your case. So as far as my announcement today, this is our first appearance together. I just want to finish the discovery and I'll be ready to go. But I'm with him, so I'm not going anywhere on his birthday application. And I didn't have the link from Mrs. Gas, but she did provide me the discovery link, access. I did get that from her, but like I said, when she emailed me, she was anticipating that Patrick would be here today as his well. But yeah, I'm ready to go to this. I'll be with you.
And what do we want to, what's your announcement today?
Just to put it on one more announcement, because I think
that'll be the fourth one. Did you know that? Yeah.
Well, what I can do is if you want me to just stay with him on the trial docket, that's cool. I can do that. Because
is that what we're going to do?
No, I didn't want to. I didn't want to because I know Patrick is going to be.
Hey, I brought out what y'all decide.
I don't want to do that. I want to put it on another announcement. That's what I want to ask. One more every day. I don't want 23.
Judge, this case is relatively newer than the other case. This offense happened in December of last year.
Okay.
So
for what?
Just one time.
I mean, we just don't say, well, no, we got several months or years. So yeah, it's up and it's ready to move. We've got things to move forward.
Yes, Judge, I understand. I just anticipated that Mr. Patrick was going to be on both cases.
I mean, it's just, they don't say this. This is the fourth setting on one of these is a fourth setting. And then on 1056. 2, 3. 4. This is the fourth setting on that one as well. And that's a lot of resettings. We move forward. I mean, Fisher could wait. We make the decisions. They're in the times. Yeah, everybody gets a year or 2 or 5 to figure it out. I'm not, that's just not the way it is. So say in the trial document.
Thank you,
and you tell Mr. Pageant it's set on the trial document. Y'all get ready. So something on this.
Thank you, Judge.
Yeah, so let's just settle that. Edwin Jones. Is that reset again?
Yeah, do 205.
You know what? Judge, Mr. Barback is probably still in trial in Orange County.
Is it reset or is Edwin, is Edwin Paul Jones? Is that you? Come on. Have you talked to your lawyer lately?
I don't talk to him.
Ever?
Yeah.
Don't tell me that.
Judge, we've been up here. This is mainly for the restitution.
I'm talking to you recently?
Yeah.
Okay, we're gonna give you a resetting on this, okay? Okay, Mr. Franklin? Your defendant is here?
Yes, sir.
What's his name again?
We call him Avi.
What, no, what's his full name?
I will let him tell you.
No, you're the lawyer. I'm gonna. Indian, Pakistani, Indian? Oh, yeah, Ale. Shukriya. Thank you. Let's see. Yeah. You know how many letters Lakshnana's last name is? How many letters?
I haven't counted,
Yes.
Judge. 16.
You're right. That's exactly right. 16. it's beautiful language and long letters and really pretty language. Anyway, what are we going to do on this?
John, this was a joint investigation with multiple departments.
I didn't have anything to do with it.
And we discussed before and again, some outstanding discovery issues, and the state, I believe, is going to reach out to Baytown, double check on some of the discovery that probably exists. And so we're trying to resolve that discovery issue.
Things are happening in Baytown. Or
Baytown was involved in this investigation.
was that Harris County?
I think so.
Yeah.
It was here. It was here in Jefferson.
The offense occurred.
In it.
They were cooperating with the Department of Public Safety on this investigation.
Okay. Does he have cases in Baytown?
No, Judge.
So what do we care about? I mean, this is his case.
There was a material witness who is a detective in Baytown.
Okay. In part of the investigation?
Yes.
Yes, Judge.
So what about it?
We just need to contact the agency and make sure that they have given us everything on their end.
Okay. Good. It's been over 4 months since this thing was indicted. What are we going to do about getting them? Contacting them? You're going to do them?
Yes, Judge.
Immediately? Okay.
Yes.
5 weeks. Have them time to get stuff. They have time for me to have.
4 weeks. Yeah, 4.
Understood. You're just on days for you.
Okay. Thank you for the information.
Thank you, Ryan. That's compliment.
Pedro Lira. Hello. What are we on? You're asking for early release from first screen.
On this was.
They do it this year?
One of our success stories, I believe.
Okay. Okay, the defendant was on this.
Ms. Tranter, anything on behalf of the state?
Your Honor, just to, in addition to our discussions in chambers, there was is a restitution request in this case for the court's information, $4,198.74 for car repairs, damage done to the vehicle. The victim being Jesse Carter.
All right. Anything else?
Nothing further.
Mr. Torek, anything from probation?
Nothing further, Your Honor.
Mr. Kidd.
Your Honor, in regard to Ms. Teagarden, I know it's been a rocky period of time for her. She has made some real efforts. She has had some real challenges as well. Your Honor, we know what the recommendation of probation is. Yeah, we're supportive of that recommendation. I've talked to her about the 1 to 5 assessment as to her need for treatment, drug abuse treatment, and she says she's not sure what that meant or where it came from, but she very much knows that she does need treatment. I think she's communicated that to the court through letters, that she has sought some sort of treatment program at the coach or otherwise, wherever the court might be. Your Honor, she's never been to prison before. This last failure to appear actually wasn't a failure to appear, but the revocation of her bond. She was dealing with her son who had a significant charge as a juvenile delinquent in Butler County. She was trying to manage that to some extent, try to spend some time with him, and she simply did not provide the priority to her own case that she knows that she should have done. Your Honor, we do think that she would be able to be supervised on probation. We recognize that pretrial is some sort of a indicator, but right now, knowing that she is a hair's away from prison, and obviously would be heading to prison with any probation revocation, I think that would provide an incentive that has not been there yet for Ms. Teagarden. Maybe it should have been there, Your Honor, but it has not yet been there. Your Honor, she knows she came in, that she tested positive. She knows she has a drug issue. Yeah, and you'll have a chance to talk to the judge as well. Yeah, but we are requesting that she be placed on community control, that she be able to follow the recommendation of probation in regard to her sentence, and that she'd be able to prove, and she knows she would be on a very, very short leash. Yeah, if she were on community control, that any mistake, any leaving of the program, any inability to communicate with probation would be fully grounds, and she knows would result in her going to prison if she were to come back. So that's what we're asking. I know she wants to talk to you as well.
Ms. Teagarden, anything you want to say?
Yes, sir. When I was released for the PSI, my son was also on PSI, and I really thought I could handle both of them at the same time and got overwhelmed. When Mr. Brown asked me to come in to see him, I got scared because I couldn't get a ride the first day that he wanted to see me. And the second day when he called me, I just didn't answer because I was scared that he was going to lock me up because I missed the first day. I just didn't come because I wanted to be there for Caden and his court dates, and because I'm all he's got. But now that he's sentenced, I know he's doing 6 to 9 months, and he'll be released at the end of November, beginning of December. And I just want to be a part of his rehabilitation as well as mine. And I did say in my PSI that the coach had evaluated me and told me that I could probably benefit from treatment. And I would like to go to treatment or have the opportunity to please go to treatment before going to prison.
Ms. Teagarden, this always confounds me when someone says they know they need treatment, and here we are, this case has been pending for some time, and yet you have never sought treatment. I don't know what, if you, ma'am, don't, please. Is there something else you want to say to me? Then say it now.
Yes, sir. They came to evaluate me, not this time, but the last time I was in here, because I reached out to peer support to ask for the coach to come see me.
Okay, and then since that time, you had been released from the county jail, correct?
Yes, sir.
Did you engage in treatment when you were
I was
released?
dealing with my baby's PSI.
Okay,
sir.
and you see, that's my point. You had an opportunity, if you wanted treatment that you now are telling me you desperately need. You could have. It's like what are you waiting for? You waiting for me to order it? I don't understand. You have you've never completed your high school education. You have no driver's license, no job, and with your criminal history, you're not exactly a great role model for your children, who you have custody of none of.
I have custody of Caden.
Who's in custody himself, right?
Yes.
Right. Oh, so you just proved my point. Ms. Teagarden, I gave you 3 opportunities on pretrial. The last one was disastrous because you not only didn't show up, didn't do anything, knowing that I was going to sentence you in a few weeks because I released you on February the 9th, the day that you entered a plea. I gave you an opportunity to prove to me that you, in fact, could comply with the rules and orders of the court, and you didn't do it. And not only did you not do it, didn't show up for your interview, didn't show up for your assessment, didn't follow the rules of your supervision. On top of all, is there something else you want to say?
I did my assessment. I did go to him the first time that I was supposed to go to him. I only didn't go the second time.
Okay. You didn't complete your assessment. That's what you're making my point for me.
I did it. He did
Ms.
it.
Teagarden, I'm done. You also, on the last time, tested positive for methamphetamine, amphetamines, and MDMA, correct?
Yes, sir.
All right. Courts considered the statements made here today to pre-sentence investigation, the purposes and principles of sentencing, the relevance, seriousness, and recidivism finders. The court does find that you are not amenable to community control and that prison is necessary to fulfill the purposes and principles of sentencing due to your extensive criminal history, your failure to respond to any of the court's conditions and your pretrial supervision. So at this time, the court is going to order you to serve 9 months in prison. You have 80 days jail time credit. Ms. Tranter, did you give me a number for the restitution?
I did, Your Honor. I can give it to you again, though.
Yeah, we would object to that. We would request a hearing on restitution.
How soon can we set that?
I'm not sure because the victim is out of state, so I'd have to see when he can make arrangements.
All right,
to do
set the
that.
restitution for hearing. Other than the restitution, the court does find that she's indigent for the purpose of other fines, costs, or financial sanctions. You're also subject to a discretionary period of post-release control, which means when you are released from prison, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, that can be provided to you. Ms. Tranter, is there anything else?
No, sir.
Mr. Kidd?
No, Your Honor,
All right,
thank
that's
you.
all. Thank you.
That tells me in writing that you don't have the funds to hire a lawyer and want one appointed. All right, I do find that you're indigent for the purposes of hiring a lawyer in the case. I'm going to appoint Mr. Guyman to represent you. You have his contact information there. We're also going to send him an email today that lets him know that he's been appointed. I'm going to set this for a final hearing, give the opportunity for the prosecutor's office to reach out to the victim in the case, and then we'll see where we're at the final. All right, that's all. Next is the case of the state of Ohio versus Robert. Is it Frey or Fry? Robert Fry, case number 25 CR 43072. Present before the court is Mr. Fry. We have Mr. View from the prosecutor's office, Austin Wilkinson from probation. We are here today because I've received a report that alleges you have violated the terms of your supervision, that you were positive for methamphetamines on April the 24th. You have the right to be represented by a lawyer in the case. If you can't afford one, I'll appoint a lawyer for you. Do you want to be represented by a lawyer?
Yes, I believe I should.
Are you going to hire a lawyer or do you want one appointed?
I can't afford one.
All right, Ms. Carrilco has an affidavit that tells me in writing that you don't have the funds to hire a lawyer and want one appointed. Who are we appointing?
Nate Elter.
I do find you're indigent for the purposes of hiring a lawyer in the case. I'm going to appoint Mr. Elter to represent you. You have his contact information there. We're also going to send him an email today that lets him know that he's been appointed. I also think it makes sense for us to send a referral for a CBCF evaluation between now and the time that we come back. Anything you want to tell me today, Mr. Fry?
I'm a little more clear about how the probation, the violation with the probation works that I wasn't clear about before. It will not happen again. I can guarantee you that.
Did you think that the terms of your probation allowed you to use meth?
No, it did not. No, I did not understand what I should say. How can I, let me rephrase that. What I didn't understand was that I would be brought into custody right away after the one time, and I didn't, and that's that. I didn't, and that doesn't matter.
Kind of matters.
Well, no, I mean, it doesn't matter. What matters, it matters, but it doesn't matter to me. I'm not saying this correctly. I understand very clearly that if I use meth now or ever again, I'm going to jail. That is much better. I have a much better understanding of that now than I did before. I did not understand. I understood that, but I didn't think it was like if it happened once, it wasn't. I was going to jail. I didn't.
But Mr. Fry, it did happen once, and you didn't go to jail. Officer Sukovecki gave you a technical sanction in mid-April for using drugs, meth, and then we had this positive test since then, right?
Correct.
Maybe the better thing to do, Mr. Fry, and like I said, if you want to keep talking, you can.
No, I don't need you. I don't.
Maybe the better thing to do is to put your thoughts together, maybe write some stuff down between the time that you and I see each other next time.
I'm perfectly willing to go to a higher level of care. I mean, that's where I come from. That's what I'm thinking.
Okay, well, that's what we're looking at. So I do find there's probable cause to believe you have violated the terms of your community control.
Oh, it's not. There's not probable cause. It happened.
Okay, I'm going to appoint Mr. Elter to represent you. Talk to him. I'll see you in a week or so.
Okay.
All right.
What about increasing my level of care? I mean, that's what Kovecki said, and
That's what we're going to talk about at the final hearing.
Okay.
Yeah, I mean, her recommendation is not to send you to prison. Might be that we're looking at a community-based corrections facility. Might be looking at a higher level of care in the community. We should know that soon.
Okay.
All right, that's all.
Thank you, sir.
Case of the State of Ohio versus Brian Hollingsworth, case number 23 CR 40152. We are here today for an early termination hearing. Officer Henry, you're here on this, right?
Yes, Your Honor.
All right, what do I need to know, if anything?
Your Honor, Mr. Hollingsworth has been on supervision with Warren County Adult Probation since July the 19th of 2023. He is just short of his 3 years on supervision. Since then, he has done very well on supervision, has not had any notable issues on supervision, has completed his court-ordered T for C. In addition to while he was on supervision, he had engaged in mental health counseling, has been doing very well. If it was originally with Access Counseling, but is now with Recovery Defined at this current date. He and the victim live together as a family. They have not had any reported issues to me, and it would be my recommendation to the court that a successful early termination of community control.
Mr. View, anything from the state or from the victim?
I don't see that we've had any other contact with the victim, Your Honor. Nothing additional from the state.
All right. Anything you want to tell me, Mr. Hollingsworth?
I just appreciate the opportunity and the understanding of the courts and probation and everything, and allowing me and my family to try to heal and help me get better standings with my mental health.
All right. Seems like this is a success story on many levels, Mr. Hollingsworth. So I'm going to go ahead and successfully terminate you from supervision. Good luck to you.
Thank you, sir. It's very appreciated.
Next is the case of the State of Ohio versus Gracie Barnhart, case number 24 CR 4200. We are here today for the purpose of an early termination hearing. Mr. View, anything from the state?
No, Your Honor.
All right, I am going to grant the early successful termination from probation. Next is the case of the State of Ohio versus Justin Zeke. Did we do a restart? Oh, 24 CR 42213. We're here today for an early termination hearing. Mr. View, anything on behalf of the state?
No, Your Honor.
All right, I am going to grant the early termination for Mr. Zeke. And that is a wrap. On the morning docket.
Ended up disposing of this case about a year ago for a Class B misdemeanor. He was originally prosecuted with an indictment of a third-degree felony, and it was reduced to a Class B misdemeanor, and he was placed on 2 years deferred or unadjudicated probation. And that was as of May 14th of last year. I see there's a motion for early termination. That's why you're here, Paul.
Yes, sir.
Here. Much longer than that.
I wrote a note, the probation on that. That's what I think got this. It's, I asked probation because I received something back in March that was all very good.
Yes, sir.
For his response to probation. What have you learned?
Don't ever make mistakes again.
Well, you're going to make mistakes. We all do.
There's,
You know, but it's how you deal with your mistakes. That's the test. It's a character. How you respond to them and how you avoid committing the same mistake twice. So repeating. What does state say on this?
I've got probation. I have no objection, John.
Done.
Thanks, Judge.
Okay.
I believe it's in the e-file.
Sir?
I believe an order's been transmitted via e-file. So probably done yesterday.
I do have one here.
If we have it.
Here, this is one. Wow, that's right. That's the one.
That's the one, okay.
Uh-oh. 28th, 29th, 30th. I don't know. I was swift.
So 29.
Champagne and ribs last night, and I don't know what day it is.
Yeah, so.
Must have been a million people here. Must have been a million people in the city center. Well. That lady puts on, does great things, and it's a lot of folks support her. Regina Rogers, very sweet lady and great asset to this community and her family. Okay, so on this day, this case is dismissed, do well, and sin no more. Okay.
Thank you, Judge. We've been Houston.
See you.
Appreciate it.
Okay, Felix Benoit. Where are you? Your lawyer is not here yet, right? He's outside? Where is he?
Standing right outside.
Oh, is he shy? He's.
Just a few minutes.
Sir.
Gertz has never been shy before. I don't know why he just had a character change all of a sudden.
Thank you.
That's okay. We'll get back to you when he gets back in. Felton Carrier. Yes, sir.
Plea, Judge.
Okay. Come on now. What's this Von Dutch? Are you Dutch?
That's
What's the clothing line? I've never heard of it.
Overpriced apparel.
Well, I know what you're in line of the Salvation Army.
I get my stuff out of the.
No, I know.
They can do it.
No, I don't. That's why I'm laughing.
Where do you buy that from? Can you buy it Any
Speaking about the bond Dutch.
The Von Dutch?
Online.
It's an online,
Yes.
because I've never seen it. Yeah. My wife is kind of a fashion.
You get one to
person.
Be prepared.
24 CR 62 is called the State of Texas versus Felton Carrier. You were here with Mr. Kimler, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
So where do you?
In summary, this indictment alleges that on or about July 24th, 2022, wow, this thing was old.
He was subsequently to this offense, subsequently placed on probation. He's on probation now, so this is going to be going exactly for probation.
It took a long time to.
Probably the lab, your honor, spent on it. They have to check for Delta 9, THC.
And it alleges that in Jefferson County, Texas, you committed the state jail felony of illegal possession of marijuana of more than 4 ounces. Do you understand what you're charged with?
Yes, sir.
If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. You understand?
Yes, sir.
It's been reached in your case where you would be pleading guilty and sentenced to 2 years in state jail. Then that would be suspended. You were placed on regular probation for 5. Do you want me to circle years? It's 5 years. Okay, no, I can do it. Yes, I can do it. It's 5 years. There is no fine here. Is this your understanding of the agreement?
Yes.
There will be terms and conditions of probation, which are normal and customary for this type of offense. If I follow this agreement, so you have no right of appeal of your case, do you understand?
Okay.
How do you plead to this indictment, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty?
Because I'm guilty.
I mean, nobody's forcing me to do this. Okay. I show you which Marcus states you did it. What? Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
States Exhibit 1 is without objection. Yes, thank you, sir. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in the new lesser included offenses. Mr. Gertz, would you please hold it now?
I call that, Judge.
It was actually a baby, that was out in the crowd. But Ryan was right in the line of what I said, so I just.
He does slightly resemble the drug to make it.
All right, this plea is voluntarily and freely made. You understand what you're charged with. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this says is true, so help you God.
Yes, sir.
States Exhibit 1, part of the record for all purposes. Pre-sentence report is hereby waived.
So,
I will follow this agreement. I'm going to find, sir, you are mentally competent to enter your guilty plea. It is freely voluntarily made. There is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony of illegal possession of marijuana of an amount more than 4 ounces, but less than 5 pounds. That's a state jail felony. I am following this agreement. You are hereby sentenced to confinement in the state jail for 2 years. That confinement is suspended based on regular probation for 5 years. You do well, it will be shortened. That'll be
yes, he has 7 years left.
Okay. Well, that's the rule for that one too. What was it?
Felon possession.
There will be terms and conditions of probation here, which are normal and customary for this type of offense. Make sure you follow them. If you fail, your probation could be revoked and you could be sentenced up to 2 years in the state jail. That's state jail time is almost day for day. We get a lot of early parole under that program. All right. Fixing all this mess?
Yes, sir.
Good for you.
This is probation. How long have you been on probation?
It's not just probation, it's just your whole life.
Working and stuff.
Okay, you have a family?
Yes, sir.
Okay, you have children too?
Sir.
Children? You
Yes,
got
sir.
children?
Yes, sir.
Well, you're the role model.
So.
You gotta act responsibly because the children, they'll do just what you do. If you make mistakes, they're gonna say, well, Dad did it, I'll do it. And I can tell you're better than that. You're not, you shouldn't be here.
No.
You have a better character. Fix it and move on.
Yes, sir.
Okay.
Thank you.
Yes.
All right.
No,
There's no fun. Hey, I've got Shelby Smith.
Satisfying.
Yeah.
Smith.
25 CR706 is now called the state of Texas versus Shelby Smith. That is you. Present, your attorney, Mr. Kimber, and the state's attorney. Earlier. Earlier, you pleaded to the third degree felony of evading arrest, or detention with a motor vehicle. That's a third degree felony, which carried with it up to 10 years in prison. The agreement here is that whatever sentence shall not exceed a cap of 5 years in prison. So we are looking at no less than 2, no more than 5 years confinement in prison. The further unadjudicated probation can be assessed. About this news on. The pollen is out there, folks. Also, you could be sentenced
Would you like me to move?
to no less than 2, no more than 5 years confinement in prison. That sentence could be suspended and you could be placed on regular probation for up to 10 years in length. I think those are your 3 options there. And a pre-sentence report has been prepared and the parties had an opportunity to review it. And are there any corrections or changes to it?
We reviewed it, no objections, sure.
All right, it's made a part of the record for all purposes. Go ahead, state can go first and we'll let Mr. Kendall have.
I'll reserve, Your Honor, and allow.
Go ahead.
Defense to go first. Your Honor, I don't know that Mr. Hand's recommendations would be subject to the pre-sentence report. I would just observe that there doesn't appear to be anything in the pre-sentencing report that would be indicative of some sort of really egregious evading. I think what happened here is that the panic was probably not in the best mental state at the time this occurred, and then
why not?
Well, and that's what I was going to address further, John. Is that along with the poor decision making capacity on her part. I think that there was no issue as far as contraband being in the vehicle that she was intending to evade the search of the vehicle, another felony case, other felony prosecutions. Additionally, she didn't have a warrant. There was really no good reason for her to evade other than just poor decision making and perhaps mental stress.
Mental stress for what?
Well, I'll let her address that. I'm not, I don't know. Been talking to counsel that she's now as far as the specifics of that and cost factors. I note that in the pre-sentence report, moral recognition therapy is recommended. Actually, research what moral recognition therapy is. It's a 12 to 16 week course that involves group sessions and individualized counseling designed to use the conate portion of that to address
Well, we do it regularly.
decision
We
making.
have it ordered in a regular
Yes,
fashion.
sir, and I believe it's what appears
I
to
hear
be
it's supposed to be effective.
an efficacious program. And as far as aiding her in making better decisions and engaging in better decision making processes, her cognitive abilities before making decisions. There also seems to be an ethical or moral element to this. Program, which also probably would be beneficial to her, although I'm not sure about moral imperatives stopping to interface with law enforcement, legally down to the, I suppose there might be a moral inclination to do. And of course, that was addressed in the program. And I think that's something she would benefit from. And either making better decisions in the future. I'll defer to Ms. Smith to maybe give the court a better idea of what our thought processes were at the time. The offensive attorney, you want to tell them?
There's an elephant in the room here. The elephant in the room is
Substance abuse.
you got 7 other cases pending.
Those are Tyler, somewhere in Tyler.
I don't care if they're,
I'm going to address.
as long as they're on this planet.
I think that what's going to happen
I mean-
there, and talking with the prosecutors, they're looking at what the court's going to do here.
Well, and this is a fact here. I just want to make sure you were on probation from Orange County when you committed this offense, correct? You have to speak out.
Yes, sir.
So you can.
Yes, sir.
Okay.
Sorry.
Okay, so you're on probation for a illegal possession of controlled substance. It looks like some kind of it's a state jail felony. Then you commit this offense and thereafter being placed on probation, and then your probation was revoked. It looks like a year ago or so, February a year ago,
Yes,
correct? And you were sentenced to 18 months in the state jail.
Yes, sir.
Did you complete that sentence? When did you complete it?
Um,
You must have had some additional time already.
yes, sir, I did. I got out, last summer.
Oh, you didn't spend long, is what
Yes,
you're
sir.
saying? Okay. So you're on probation, and then that was revoked, and then you were sentenced to 18 months on that one. Then it looks like all of these are the same. Well, there's not all the same date. You got 1, 2, 3, 4, 5, 6 burglaries of a building, burglaries of habitation, engaging organized criminal, tampering and fabricating with physical evidence,
That should be child care.
and possession of a controlled substance. All in, the date of offense is February 16th of 23. And that was, it looks like before you were placed on probation in Orange County that was later revoked till last year. And then those are all pending cases. Those haven't been disposed of yet.
That's correct, Your Honor.
Oh,
Representative.
okay. Then you've got this new evading arrest or detention with a motor vehicle, the 3rd-degree felony that pops up, and it is committed on November 12th of 2024 after you were on probation for that Orange County case. And after it's alleged you committed 1, 2, 3, 4, 5, 6 offenses out of Tyler County that are pending. Then I didn't even talk about the misdemeanors, Richard. We got evading arrest or detention pending in Tyler County. A failure to identify in Tyler County. And then you receive 30 days in jail for a theft of property, I guess, here in Jefferson County. Is that right?
Yes, sir.
What's all this all about?
I had lost my daughter and I was kind of spiraled out of control.
When?
Let's see, about 4 years ago.
What was the date?
When I lost my daughter.
Yes.
But
You certainly know that.
No, but she didn't.
We all know when
No,
we lose a child,
CPS.
exactly the moment that happened.
Well, it was, she didn't pass or nothing. It was the CPS. I lost her to CPS.
Oh,
Yes. So.
why?
Because her father, got caught with drugs.
Because of her father? You
Well,
lost?
yes, sir. So she,
That's not the way it works.
well, he had said that I was a dangerous child.
Well, they must articulated some reason.
Right.
Okay. Nonetheless, so do you have any children? Ask.
I have 13-year-old.
That's in your care.
Yes, sir.
What about that? I mean, you're committing crimes here. You can go to prison for a long time if you added all this stuff up. And you got a child at home?
Answer out loud.
Yeah,
Yes, sir.
come on. But on one hand, you say, well, I'm suffering because one of my children were taken away from me, but you have a child at home that's you're responsible for, and you've got all these crimes. That doesn't make any sense. Ma'am?
I was kind of hanging around the wrong people.
Whose choice was that?
No.
Okay, what else? See, these are your choices, like we all make it. These are fixable by doing the right thing. You know it's the right choice. We all know. You consciously continue to make the wrong choice. Which is I wish you wouldn't do. Not only for your sake, for your family.
So
where are you in things?
right now I'm having trouble. I'm making better decisions now.
Okay.
But I think maybe I just needed to see that making bad decisions because of consequences do. Like I said, I just wanted to. Because yeah, so I got locked up in a offer.
Yeah, there's a great book written by a person named, it says, I am third. I am third. Our creator is first, others are second, including our family. I come in third. And that's,
yes, sir.
It has a good message. It certainly plays out a lot here in this room. So people who forget that they have responsibilities that are more important than them, especially family. You didn't get to pick them. I mean, people, our creator gifted you with that. All right. So what do we do?
Well, I would suggest defer to adjudicated probation, not because, our 10 over 10 is a third degree, I suppose. You wouldn't extend their exposure if you go defer. If you sentence her to 5, if you knock her out, Your Honor, parole being what it is with a non-aggravated offense, you probably would do it the most too, as long as she doesn't get any type of problems when she's in institutionalized. So I think probation actually may be the harder course for her at this point with the exposure. You're doubling her exposure to 10 versus 5 in the event that she isn't able to maintain a law-abiding lifestyle and abide by the conditions of probation. So arguably, I think that the probation is a harder sentence potentially than the 5. And again, she evidenced as far as her behavior since being released from state jail, not accumulating any other cases. Other than this, I suppose, with Alpine State, that she is amenable to rehabilitation and amenable to the MRT program. So I would argue that the interest of society would be better served if she were placed on probation and attempt to rehabilitate her and incarcerate her.
I have a different opinion about all this, Judge. I want to start with number one, the classification the defense has given you about this offense. Having watched the video of her evading here, we're lucky that she's standing here. It's the risk of life that occurred here whenever she's disobeying all the traffic lights on 11th Street from 11th and Laurel all the way down to Luby's. Again, it's just amazing. And I made those comments in my notes, and I don't usually do that unless it's something that is notable that I plan to use in trial. What is missing from this PSI is what they found in her car that I hope explains why it is that she was running. According to the officer's report, when they inventoried her vehicle, they found a checkbook inside her purse that belonged to another individual by the name of Elizabeth or Martin Graham. In addition to that, they
Who was that?
I'm not sure. I don't recall.
All right, go ahead.
In addition to that, they
I
found
know all the checkbooks in my car. I know whose they are.
They found
everybody pretty much does.
They found an EBT card and Social Security card that belonged to a Julia Glover. In the same stack of those cards located.
Who's that?
I have no idea.
Okay.
7 medical insurance cards, another Social Security card, a different state Texas
driver's license card, 2 bank cards, a different food stamp card, 2 scrap metal cash transaction cards, all belonging to other individuals. Now, Your Honor knows.
Or other names.
Right. That could have been a separate offense altogether. And why they didn't charge that's a law enforcement decision as far as that's concerned. But this certainly explains conduct underlying as to why she did what she did on that date, not this explanation that was provided to the PSI officer. The state of Texas feels that probation was offered to her in Orange County. That resulted in a motion to revoke probation because of this offense. It's why she was revoked and given the 18-month state jail time. She had, and again, I don't understand why Tyler County's 8 pending charges. You said 7. I don't know why these weren't resolved prior to her going on probation, because those offenses.
Yeah, I'm only counting 7 here in the percentage.
I counted.
But that's
I may have miscounted, Judge.
I don't think there's a substantial difference there. There's a lot.
There's 2 misdemeanors and 6 felonies. They all arise from February 16th of 2023, all along the lines of the kinds of things that we're talking about. Evading. There's an obvious trend here about the criminal activity that's obviously present here on this date that we're dealing with. So it's no wonder they're waiting to see what Your Honor's going to do on this case before they decide what to do here. I know that if she was on our probation here and that was ours, I'd be asking for prison time. Just because the fact that it's in a different county and we've got this same deal, I don't take a different position. She had her chance. There's not a reason why we should reward her for successfully not killing anybody on that day and give her probation. That's not what's warranted here. And then what really says a lot about this is when you get into the PSI's writing here, and she's talking to this person that's giving you this report, she doesn't seem worried at all about it. That's when she's having her candid one-on-one conversation before she appears here. And that's what the officer writes here on underneath the recommendations. She refers to her pro-social and antisocial behavior throughout the interview. Those are comments that have just not been addressed by anything that we've heard here. The cap is 5. 5 is what I'm asking.
Okay. Anything else, Mr. Kimberly? What do you?
I respect Mr. Hand's opinion. Obviously, it's predicated on some factual arguments.
What do you think is best for your client?
I would submit to the court that she is amenable to rehabilitation. That appears in the pre-sentence report through their recommendation. They're not recommending probation.
Credit for, man.
I would just suggest to the court that she is someone that is eligible, and you could place her on 10 years probation.
Have you been on bond?
Sir.
Okay.
When did you make bond?
For this count.
How long have you been out?
For every
December, right before Christmas.
So December.
So like
financially, how did you do that? Because are you retained, Mr. Kim?
Yes, it's her brand.
Okay, somebody helped you on all of this, and you've been out for how long?
About 4 months.
30. You only have about 30 days credit on all of this. I was just curious. All right. Anything else? Anything else you want to add?
No, sir.
Okay. Stanley. Right. Do you have another case?
I'm over in drug court. As soon as I finish here, I can come back.
Can you come back on that? Because I'm going to put you over there in the box and do something here. Think about something. Okay.
I'll come as soon as I finish. Honestly.
Okay. Brittany? There we go. Alexander.
It's right here, Judge. It's the one you gave to me earlier. It's an unindicted case.
What are we doing?
It's a great thing. A bond reduction.
Okay. Where is the charging instrument?
It's not indicted, Your Honor.
Was there a complaint though filed?
No, all we have is a PC. We have that's all we have.
Is that it?
I don't know. Is this a writ or what is this?
Yeah.
Yeah,
Case hasn't been indicted.
it looks like a pre-indicted case, but I'm looking for. Isn't there normally a complaint?
The only thing I was provided was a probable cause affidavit.
And that's all I'm showing up here, but there's a charging instrument, isn't there?
No.
No.
There's you got
I don't know if
a probable cause affidavit that supports a warrant for his arrest.
Sure.
I don't even see a warrant for his arrest, but I'm sure one was done. And I have a public safety report, by the way, which is always required that shows no criminal history.
Yeah.
Only this deadly conduct on March 16th, which is represented by this probable cause affidavit. Okay, this is the Rogers Park situation?
Yes, Your Honor.
Terrible situation. What do you ask? What's the bond now?
500,000.
Why not?
Well, Your Honor, Mr. Perkins has been in custody for 45 days at this point. And this case is still not indicted. His family has tried to secure the bond at the current amount. We do believe, based on the average.
On behalf of the state of Ohio, with regard to case number 42968, that is set for a jury trial to begin May 14th. Anything for the record on that case?
Nothing from the state, Your Honor.
Not at this time, Your Honor.
On case number 42977, Ms. Tranter.
Your Honor, my understanding is that Mr. Oldham is going to be entering a plea on that case number to count 1, improperly handling a firearm in a motor vehicle, as well as the specification for the forfeiture of the weapon, as well as count 4, which is falsification misdemeanor of the first degree.
All right, Mr. Brenner, is that accurate?
It is, Your Honor. Discussed that with my client. We are prepared to plea as Ms. Tranter just outlined.
Okay, Mr. Oldham, you're telling me you're going to, on the second case number that we're going to, you're going to be changing your plea to guilty to 2 counts. One of them has a specification. Before we get to your change of plea, I am required to go over some things with you, okay?
Yes, Your Honor.
How old are you?
19, Your Honor.
How far did you go in school?
I'm still in school. I'm enrolled senior year.
Okay, so are you able to read and write okay?
Yes, sir.
Are you a citizen of the United States?
Yes, Your Honor.
Has anyone promised you how the court would sentence you in this case?
No, Your Honor.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, Your Honor.
Are you satisfied with the representation you have received from Mr. Brenner?
Yes, Your Honor.
Are you currently under the influence of any drugs or alcohol?
No, Your Honor.
Do you take medication that interferes with your ability to understand what's going on today?
No, Your Honor.
I have in front of me a document called a change of plea. On the second page, on the line marked defendant, there appears a signature. Did you sign this?
Yes, Your Honor.
Did you read this and go over it with Mr. Brenner?
Yes, Your Honor.
And you feel comfortable that you understand what it says?
Yes, Your Honor.
All right. This document says you're entering a plea of guilty to 1 count of improper handling of a firearm in a motor vehicle. As a felony of the 4th degree, that carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. The prison term is not mandatory. That also carries with it what's called a specification that the weapon would be forfeited. The second count is one of falsification, a misdemeanor of the 1st degree. That carries a maximum penalty of 180 days in the Warren County Jail and a $1,000 fine. Do you understand the maximum penalties?
Yes.
In addition to those penalties on the felony charge, you are also subject to a discretionary period of post-release control. If you are sent to prison on that charge, when you are released, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. You understand that?
Yes, Your Honor.
But it's not mandatory that you're sent to prison at all. The court does have discretion to place you into community control, or what some refer to as probation. While on community control, you will have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of the charges from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
All right. You understand that when you enter a plea of guilty, you will be waiving all of these rights, at least as to this indictment.
Yes, sir.
That's how you want to proceed today.
Guilty, Your Honor.
All right. Ms. Tranter, statement of facts, please.
Your Honor, this incident occurred August the 18th, 2025, Warren County, State of Ohio. On that date, Duran Olden III did knowingly transport or have a loaded firearm in a motor vehicle in such a manner that it was accessible to the operator or any passenger without leaving the vehicle. And in addition, he did knowingly make a false statement or knowingly swear or affirm the truth of the false statement with purpose to mislead police conducting an official proceeding and investigation.
Mr. Brenner, anything on those facts?
Nothing on those facts, Your Honor.
Mr. Oldham, did you hear the statement that she read?
Yes, sir.
Do you admit that what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up when you enter a plea of guilty.
Yes, sir.
What is your plea?
I'm guilty.
Okay. The court's going to make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights. The court will accept your plea of guilty, and based upon the statement of facts and your plea, the court will make a finding of guilty. I'm going to order a pre-sentence investigation, and we're going to kick this down the road for sentencing. Your trial is coming up. What I say, May?
2 weeks, Your Honor.
2 weeks.
14.
This sentencing will be after that. So go back down to court services where you checked in today, because you need to schedule your pre-sentence investigation for this case. Okay.
Yes, sir.
All right. Stay in contact with Mr. Brenner.
Thank you, Your Honor. Okay, so going down there, we'll get our court date, okay? And we'll talk soon. All right.
Prior to this incident, or the average for a third degree felony deadly conduct, that this current amount is excessive. Mr. Perkins does not have the assets or any type of property that he will be able to sell in order to obtain the funds at the $500,000 amount. And based on him being in custody for this amount of time, we believe that a bond reduction is necessary at this time.
State. Judge, there were numerous people that parking in that area that had to run for cover and hide. This may be a third degree, but it could have been worse. And it's just lucky that shots did not hit other individuals and make it worse. So you've seen the response from the community in this, that they're terrified because of the violence. And this is reaching out into a public park now to where innocent people were just standing around just having family time. And so we would ask that bond stay the same, if not be raised. I can't ask for it to be raised because I don't have enough information, but I just don't think it should be lowered.
And I'm sorry, one more thing.
Yes, sir. Yes, ma'am.
I did contact the detective on this case, Detective Carmouche, at the beginning when Mr. Perkins did go into custody. We have been provided information in regards to Mr. Alexander Perkins and to him, in regards to him not actually having a firearm at this time. Obviously, that is an issue that we are going through with law enforcement, but it is our intention, if this case is indicted, it is our intention to fight the charges in regards to Mr. Perkins not even having or discharging a firearm on that day. And we do have witnesses on his behalf in regards to it.
Today?
Not today, Your Honor.
Anything else? I have 4 corners of this probable cause indictment, probable cause affidavit to go on, which in summary states that on Sunday on March 15th of this year, last month at approximately 6 o'clock in the evening, Beaumont Police Department and other law enforcement people were dispatched to Rogers Park in reference to multiple shots being fired there. The officers located multiple spent shell casings at the scene, which indicated that multiple firearms had been discharged in the area, as the bullets apparently were different calibers. And during the investigation, eyewitnesses positively identified Alexander Perkins and Dante Perkins as being among the individuals who were discharging the firearms. And based upon the evidence from the scene and eyewitness identification, the investigators state that there's probable cause to believe that this defendant, Alexander Perkins and Dante Perkins, is Dante your brother?
Yes, sir.
Knowingly discharged firearms in the direction of an area where individuals were present, thereby recklessly engaging in conduct that placed others in imminent danger of serious bodily injury or death. Could have been a catastrophic event. Do you have information of how many bullet shells were recovered?
Let me see if there's.
I'm looking at the defendant's criminal history, and I don't see anything from this public safety report except charges that are arising from this March 16th event. This is appalling. It's bad enough. It's a city. And we all know that things happen in a city when people make foolish errors, especially when you have a firearm. When you shoot a firearm, you don't know where that bullet is going to necessarily end up, and it is used to kill. You have a location here at a park where children predominantly go. Children. And y'all are going to be involved. People are going to be involved in shooting irresponsibly bullets in a park where children can be placed in harm's way, plus other humans. We all know from what this court has learned that there were numerous bullets shot, and that not only were bullets, shells found in the park, but also apparently bullets were discovered in locations outside the park where they landed. When you shoot a gun, you don't necessarily know where it's going to land, but it can cause death and serious or serious bodily injury. And when you're at a location where predominantly children go, shame on anyone who is responsible for that. The probable cause affidavit states that information from the police show that this defendant and his brother are positively identified as being among the individuals who were discharging firearms at this location. Irresponsible behavior. You won't get a reduction from me. $500,000 may, as the state says, be too little. They don't have information to provide for this court to raise it. But I am, in spite of the fact that your attorney does a valiant job in all she does, everything she does, Ms. Holmes, in due respect, I'm not going to grant a reduction in this bond, and $500,000 may be way too low when lives, especially children's lives, are at stake. Do you understand what I'm saying? So, okay, anything else? That is all.
Thank you.
Okay, how are we on probation? Don't be, I'm sorry, this is a court. Do not making outbursts. You will be arrested immediately. Thank you. That's disorderly. Thank you. How we doing?
Just a couple more minutes.
Okay, thank you. Tell the jury we're going to need about 10 more minutes and thank them for their patience. All right, I've got Ms. Smith and Felix Benoit. Is that right?
Yes.
Announcement.
Judge, we need some additional time. It'd be fine with me. This is our first appearance, so.
You got it. Okay. And the Contarius Williams was reset. That was Bruce Smith. Where's Contarius Williams? Is he in?
Judge, I have that's reset to next week.
Okay, thank you. All right, we're getting a drug test done here on the defendant before the court makes his decision on sentencing. Stand by.
From that trial, from the previous trial, two things. One that I think Mr. Wilkerson had requested, and then I had requested her
also find and transcribe for us the admonishments before Mr. Johnson testified in that trial. And so with regard to any request for any type of in the charge, anything having to do with voluntariness of that statement, if that's still going to be a request, then what I probably would do if I deny that request is make the part of that transcript a court's exhibit to send up to show that he was admonished on the record by you, Mr. Wilkerson, and also I followed up with some questions as well. So we'll get to the charge after his testimony this morning, if he still intends to testify today.
He does not, Judge.
He does not?
That's correct. After further communication regarding the matter, he is not going to testify in this case.
All right.
Regarding the voluntariness matter, what I would suggest to court is the valid admissibility is court's decision. Weight is for the jury to determine. And then relevant to optional completeness regarding the two pieces of the transcript, the court, I believe, was indicated in intent to seal one and send it up. I would also, as an offer of proof, ask that the other exhibit regarding cross-examination also be sealed and enclosed, Judge.
I'm not going to seal that and enclose it. If you want that read to the jury, then you can bring, it's certified. I've already said that I would allow something, Mr. Coleman, you can take a look at it. But the thing is, I'm not denying that now. So now I'm obviously not going to allow the whole transcript.
Middleton, we're going to take a minute and see if we can discern who's here. Was that a flash of lightning?
Julie Reed is
Irina
here.
Gonzalez is here.
Julie Wheat's here.
Just say that again.
Julie
I know
Wheat
you're
is here.
I called your name. I can see you.
Oh.
Julie Wheat. The claim is limited to $7,000. There's no formal record being made. Boy, it's really raining hard. There's no formal record being made of us. You can see it on the roof behind you. There's no formal record in a small claims proceeding. Any decision here is final. As I said, neither party can have an attorney. The rules are more relaxed. We don't strictly follow the rules of evidence or procedure. We will allow some limited hearsay in the form of letters or reports or quotes, but all the parties are under oath. Either party has the right to remove the matter from small claims to the general division of the court. You have to do it before we start. Once we begin, any decision here is final and there is no appeal from small claims. And I think everybody is ready. For those who are waiting, we will take a little time here to see if anybody shows up, and the same thing with Ms. Gonzalez. So I'm going to start with a matter that is contested. Jocelyn Rogalski versus Caleb Evink. File number here is 252447SC. This is a claim for $7,000, which is the statutory limit of small claims, for damage that was inflicted on Ms. Rogalski's car as a result of a drunk driving crash that took place last year. I'm going to ask both parties if you would please raise your right hand. I swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I agree.
I have some familiarity with this case because I handled the sentencing in Mr. Evink's case. I believe he pled to impaired driving. The matter was set for sentencing.
Yes, Your Honor.
I did restitution of the case. That any was requested, or I'm not sure, but restitution was not ordered as part of the case.
Mr. Evink is on probation right now as a result of that charge. He did acknowledge that he was at fault in the accident and accepted responsibility by entering a plea. Ms. Rogalski, your car was damaged in the extent of more than $7,000. I had this set a while ago, February 9th, but neither party showed up. Anyway, you're both here now. Ms. Rogalski, is your claim still the same, that you had more than $7,000 damage to your car and you wish to sue for that amount?
Yes, Your Honor. I do have all of the receipts available as well, and I totaled them up before this hearing, and my total is around $9,800 on top of the cost for filing this. But of course, I'm just going for the maximum allowance if possible. Thank you, Your Honor.
Mr. Evink, as I indicated, at the time of the accepted responsibility for this, you were coming out of the liquor store parking lot and crashed into Ms. Rogalski's car. Do you acknowledge that you owe this debt?
Yes, but I did have insurance, so I don't understand why insurance wasn't called.
This is a no-fault state. And so if you have insurance, you're covered by the no-fault statute. If you don't, you're subject to being sued. Now, you could have been sued by her insurance carrier. And I tell people this all the time. We get dozens and dozens of people who come in here each week driving with no insurance. And when you get in a situation like this, that you're in an accident, you could be liable for thousands or even tens of thousands of dollars if you would not be liable for if you had insurance. As I indicated, I know about it because I did the sentence. I texted or emailed your PO, Dan, to see how you were doing. I don't see a judgment in here. There it is. He didn't answer me. So how are you doing on your probation, Mr. Evink?
Well, I'm doing great. Fines are almost paid off. They'll be paid off next week or this week.
I haven't heard anything, and so no news is generally good news. Ms. Rogalski, he also owes the court money for fines, supervision fees, and that sort of thing as a result of the judgment. But let's find here that he owes you $7,000 plus $75.46 in filing fees, for a total of $7,075.46. It's a lot of money. Mr. Evink, are you presently in any position to make any payments on this?
On $7,000 right now, not really, especially with paying my other court fines. But I mean, I'll do what I have to do. I thought in the state of Michigan, if you had insurance, the largest amount they could claim was $3,000.
All right, I'm losing you. Are you employed?
Yes.
Where's that?
International Paper in Three Rivers.
Oh, that's right. Are you missing work right now?
No, I just got out of work.
Ms. Rogalski, Ms. Wheat has filed what's called a discovery subpoena hearing. We're going to address that in a minute. I find that Mr. Evink owes you $7,000 as you've claimed, and he also owes court costs of $75.46. Getting the judgment is the easy part. Getting the money is the hard part. This is an order that says he owes you the money. You can use this order to garnish his wages, to seize property, and other things. He has 30 days to pay the judgment, or he's subject to further collection. Now, he's not in a position to just write you a check for $7,000. He's paying court costs, fines. He is working. Mr. Evink, you won't like a garnishment. If she puts a garnishment on your wages, you won't like it very much. But what
I've had those.
I'm going to just enter the judgment. After 30 days, Ms. Rogowski, you can ask for a discovery subpoena.
Thank you, Your Honor.
Now, he is more collectible than many people. He has a job. He has a job that pays a decent wage, and it is regular hours and of a legitimate company. A lot of guys are working under the table, or they're working for Fred's landscaping service or someone that's hard to get a handle on it. So theoretically, you could garnish his wages. As far as he's concerned, he's got rent, car payment, car insurance, that hopefully he has, groceries, that sort of thing. And so you can't take just all of his money, but garnishment can allow you to take quite a bit of it. So it's in his interest to agree to some sort of monthly payment. Right now, he's still paying the court. So let's see if he can pay anything within the next 30 days. If he does not, you can do a discovery subpoena. So, Mr. Evink, you're going to get in the mail this judgment that says you owe $7,000, and you're an object lesson to people as why they should not drive around with no insurance and why they shouldn't do it while they're drunk. But you accepted the responsibility, took a plea, you're complying with the terms of your probation. But this is an additional consequence. Actually did almost $10,000 worth of damage to this lady's car, not to mention all the aggravation that goes with it. She's suing you for only $7,000 because that's the maximum allowed. So there's $3,000 right off the top. But I want you to think about what you can make as a payment. It would have to be something along the lines of like $200 a month. I don't know if you're presently in a position to be able to do that. But right now I've entered the judgment. If no payment is made, Ms. Rogowski will contact the court regarding a discovery subpoena, and we'll have a hearing regarding that. And then ultimately she could issue a garnishment of your wages, which you won't like, and leave you without enough money to eat. Do you have any questions?
I just have one. So I got the paperwork and everything, and the value of the car is max $5,500. How does everything equate to more than $9,000 worth of damage?
Well, this is often an issue with vehicles that you can do $9,000 worth of damage to a $2,000 car. So that's a legitimate question. Ms. Rogowski, where is the car?
Car has unfortunately been taken in by the tow company that picked up the car. I gave them the title and everything.
All right, sorry, I didn't hear all that. Where is the car?
It has been given to the tow company. They have ownership now.
Did you get that, Mr. Evink?
Yes.
Maybe you heard it better than I did. All right, the car was forfeited to the tow company?
Unfortunately, yes, it was absolutely undraggable.
So you never redeemed the car?
I did pick it up from the scene and I was able to extract my belongings afterwards, and it took me quite some time to be able to go forward with this process. And I gave them the title because I wanted to get out of that cost for the tow bill as well, unfortunately.
Boy, I'm having a really hard time hearing you. Where are you? It looks like you're in a hallway in a school building or something.
Sorry, I'm at my university because I actually have my final class tonight as well. So,
where are you?
My college, Western Michigan University.
All right.
The signal might not be good.
All right, well then it does become an issue as to the value of the car. Let's talk about what it was. The loss of my car's fair market value and related expenses. The car was a 2017 GMC Terrain, is that correct?
That was my car, sir.
All right. Your car was a 2013 Chevrolet Equinox. Is that correct? You have some bills in here. Lozada's Auto Repair, Quick Change Lube, and some other things which were prior to the car's damage.
Yes, it was just to show the work that I've done to the car.
We just went through this with the prosecutor. The fact that you put new brakes on it or a new exhaust or those sort of things a year before isn't relevant. What is relevant is what was the fair market value of the vehicle at the time of the crash. According to your paperwork, the Kelly Blue Book on the car was $2,845 to $5,508. So the car wasn't worth $7,000. The things that you did to it in 2024 aren't relevant to the value of the car. Somebody had just put 40 tires and did a bunch of other stuff and then it got wrecked. And yeah, you had some work done in the summer of 24. This accident was in the 2025. So the Kelly Blue Book is up to $5,000. The vehicle had $192,000 miles on it. Is that correct? That was a year ago. So the car had over 200,000 miles on it.
I unfortunately can't recall the exact mileage, but I believe it was in the 160,000 mile range. I'm not up that high.
Well, I'm having a hard time hearing you. Did the car have over 200,000 miles on it?
Absolutely not. I know that for a fact.
Well, in the summer of 2024, it had 192,000 miles on it.
I'm not sure where that would be typed, but I'm assuming that was a typo because the maximum I know it got to was 160. And the car that I was forced to unfortunately buy after this accident has 30,000 miles less. So I know it wasn't over 200,000. Unfortunately, I don't have the odometer to prove that.
All right, I can't understand anything you're saying. Where's your microphone? On your laptop?
Yes.
Mr. Eving, could you understand anything she said?
She said she didn't have, the car she has now has 30,000 less miles on it, but the max that it had was 164,000.
It didn't have 164,000 miles on it. It had 192,000 miles on it a year before this accident, according to the Sparkle Quick Lube in Coloma.
That was a typo by that place. I'm trying to factor again. Lozada's Auto Repair. It's maybe contacted for confirmation if needed.
We might as well be speaking two different languages because and it's saying away from microphone headphones. Even your own Kelly Blue Book values the car somewhere 20 to 55. I had an $7,000. You're entitled to the car. Next, we have just you printed off the internet. Mr. Revick, any research into what you think is worth?
What was that, Your Honor? You're breaking up.
Did you research, Carl?
Yeah, I still can't hear you, Your Honor. I'm sorry.
All right, boy, we're having communication problems. Some of it's this courtroom, some of it is for each of you are. I'm looking in the criminal case to see if I had any photographs of the car.
Did submit a video on a USB file of the accident, and I do have that available to screen share if allowed.
Ms. Evink, you're gonna have to get closer to your microphone. I mean, Ms. Rogalski, because I just can't hear you. Wait a minute, I may have some pictures. So, Ms. Rogalski, why do you believe he owes you $7,000?
I was equating the value of the work I had put into my car into the estimate prior to knowing it accounted for.
I can't understand anything you're saying. You're in a little echo chamber there and you're far from your mic. Everybody that's listening, both here on feed, online, can't hear you. So I can hear you, I just can't understand it because the words are garbled. I'm sure you're speaking succinctly. Why do you think he owes you $7,000?
Before coming to this hearing, I did not know that the previous work that I had done to my car could not be accounted for its value. So upon knowing that, I will take whatever I can be given by the court, and I appreciate your consideration.
It's raining. It's the rain. It's raining on this car. No, I can't hear her because there's an echo in there, or very poor microphone pickup. Well, your car, you said it had 168. In June of 2024, it had 192,000 miles. So a year later, it's likely it had over 200,000 miles. You're shaking your head. What's your response to that?
It was a typo, unfortunately. The Sparkle Quick Lube is not my regular mechanic, and I can again call Lozada's Auto Repair if needed to confirm that the Equinox's mileage was at 100,000. The Sparkle Quick Lube I only went to one time ever, and it was a confirmed typo. And I have even from them, but I didn't have those submitted to the court.
No, here. None of the people here you understand. I'm not sure if it's speech or if it's but all the people on the screen are so I'm stand, but
Okay, I switched my Wi-Fi, so apologies for that, and hoping that it works. Okay, I think I should be reconnected. I'm sorry about that. I switched my Wi-Fi's in hopes that you might have better signal there. I hope you can hear me better.
You switched your Wi-Fi in hopes it would be a better signal. Well, I'm not sure why you could hear it and I can't.
It's cutting out on my end too, unfortunately, so maybe it's Brazil as well. I'm not sure.
All right, I don't. In that oil change report in two different places, they report the mileage at 192,258. I don't have any reason to believe that's not accurate. So we have a 2013 vehicle with over 200,000 miles on it. It's got new tires in 2023. It's got a new exhaust in 2024. I don't know what the body looked like, but I doubt you could sell one of these for $7,000. And I'm having a very difficult time understanding anything that you tell me. So what would you like me to know?
I have a video file that I did support as well on the USB, and I have it available to you can see the accident.
Just a minute. Just a minute. Stop for a minute, Ms. Rogalski. Ms. Weed, could you unmute your microphone? Ms. Weed. All right, can you hear me?
I can hear you.
All right, and I hear you very clearly.
Okay.
So I just want to make sure it wasn't at this end. Where are you located right now, Ms. Weed?
I'm in Pivotal, in the office.
All right, and you can hear me clearly?
Yes, I can.
Ms. Gonzalez, would you unmute your microphone? Can you hear me?
I can hear you.
And I hear you very clearly. Judy, would you unmute yours?
I don't know how.
All right, and can you hear me?
Yes.
Excuse me. All right, so the problem is with Ms. Rogalski's setup. It's not the court's led, so it's just the way we're configured here. All right, I'm still trying to establish why, although it's ineffective. Every time I ask you something, you give me an eloquent answer, but I can't understand it. So, it has to do with the placement of your microphone and the space that you're in. So let's try again. I do believe that that mileage is accurate, 192,000 miles in June of 2024. You're the plaintiff, you have the burden of proof, and the evidence that you provided says it has 192,000 miles. So the fact that you say that's a mistake, somebody wrote it down wrong, the written document would be more compelling evidence. So we know you had some service done to it at the time. Previously, we're trying to determine how to put a value on it. So, again, if you can tell me why you think it was worth $7,000.
The typo is accurate. I would never buy a car over 160,000 miles, and that is what it was over when it was crashed, unfortunately. And I believe it is worth that much just because of the time, the effort, and the amount of work I put into it. If I can't get the whole amount, I would even be grateful for at least the minimum or the private party value of $4,000. Something is better than nothing, of course, and I would just like to be able to bounce back from the damages that have really set me back financially. Your time.
Basically, the time and effort and work that she put into it, she can't get the full value. She wants like the mid-range and inclusive value, $4,000.
All right, we're just sort of guessing here, but it makes a big difference to Mr. Eving. Throw some spaghetti at the wall and see if it'll stick. And I was a little hasty because of the lack of controversy over who's at fault. I lost focus on the value issue, and Mr. Eving raised it. The car does have a lot of miles. It does have a new exhaust, a year old, and it does have some tires that were 2 years old. I'm gonna grant $4,000 rather than $7,000. Which is $4,075.46. He chose not to have insurance. She chose not to have full coverage insurance. And on a car this age with this many miles, I probably would have had full coverage insurance on it either.
Your Honor, I did have full coverage insurance. I was financed on my car. I had to have full coverage insurance. I had full coverage. I was financing my car. I had like 6 months left to pay it off. So I still had full coverage on my vehicle.
All right, well, good for you. She did not, and so she wasn't covered, and so she's gone to the small claims court to recover because you didn't have any insurance on the day of this crash. So my advice is the same. I'm going to issue the order. If you don't pay anything in 30 days, I lost Ms. Rogalski. Then she can do a discovery subpoena, and we'll set up a payment plan, and you can plan on it being at least $200 a month, Mr. Ewing. But I found the car is worth at least $4,000, and that's my finding. All right, she left me. I don't know if she left in anger or maybe she just got disconnected. All right, I lost you there for a minute. Anyway, my advice is the same. If he doesn't make any payment within 30 days, you ask for a discovery hearing. Mr. Evink, I'm gonna let you go, and I'm gonna have you stay with me, Ms. Mogalski, so you can watch the next discovery hearing.
Understood, Your Honor.
All right, you're good to go.
Okay, thanks for your time.
All right. All right, Ms. Wheat, let's do yours. And then we'll do Nora's case, and we'll do our security deposit case. Our next matter is entitled Julie Wheat versus Rebecca Holden. This is an asset discovery hearing. The file number here is 251699SC. Rebecca Holden was personally served for this hearing here today, April 27th at 3 p.m., and she is not here. Ms. Rodowski and Ms. Wheat, this is not a birthday party invitation, it's an order to appear. And when you don't appear, you're in contempt. We don't have debtor's prison. You can't go to jail for not paying a debt, but you can go to jail for failing to appear pursuant to a lawfully served subpoena. Ms. Wheat, has anything been paid on this debt?
No, it has not.
All right, I'm going to issue a bench warrant for her arrest for contempt. The bond is $1,000 cash only, which may be applied to the debt. Ms. Wheat, you have additional expenses for scheduling this hearing. Do you know how much that is?
Yeah. I had to pay for them to send her the paperwork to come to this one. And my other statement that I did was for the 16. Oh. And what else? $56 is what I had to pay for this time around. And my judgment for the last one was $1666.25.
All right, those costs will come out first.
Okay.
Now, I'm going to issue this bench warrant. You need to call the clerk and discuss this with her because you need to help provide the warrant. Now, if she gets arrested and she can't post $1,000, she sits there until such time as we can conduct a hearing. So if she gets arrested on a Friday night, and she doesn't have $1,000, she'll sit there until we can contact you Monday or Tuesday and set up the hearing. Then I'd let her out of jail. If she posts $1,000, she'll be released and we'll schedule a discovery hearing. But as I said, she was personally served with this and knows she was supposed to be here.
Yes.
So if Ms. Holden, if you hear this, you need to contact the court. And Ms. Wheat, I want you to contact the court when we finish here today regarding the bench warrant.
Okay.
All right, we'll see. Diligence does pay off. People that continue to do the discovery hearings eventually make enough of a pest of themselves that they get paid. And we'll see how this works. So Ms. Rogalski, if he hasn't paid anything in 30 days, you contact the clerks, ask about setting up a discovery hearing, and they'll assist you with that. All right, you're good to go. Miss Wheat, you're good to go.
Okay.
All right, Ms. Gonzalez, let's take up your matter. This is, oops, wrong case. Myrna Gonzalez versus Roberto Alves, file 26374 SC. Ms. Gonzalez, would you raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes, sir. Yes.
As I'm sitting here now, I don't believe I ever swore the last parties. Ms. Gonzalez, you have sued Mr. Alves for some service he did to your car or either didn't do to your car, but you paid him $2,549.03. Is that correct?
Yes.
And you had additional problems with the car. He never provided you with information regarding the alleged scans he did on your car. And you've asked for that money back and he's failed to return it. Is that correct?
Yes. Yes. So I went to his auto place for 2 new tires. When he returned the car.
Well, yeah, you dented your car all up. Correct?
Yeah, I went for 2 new tires. And when he returned the car, he had damaged my driver's side door.
Well, he isn't here, so you automatically win.
Okay.
That's called a default.
Okay.
And when you don't come, you don't have to come in a civil case, but if you don't come, you automatically lose. So I find that he owes you $2,489.03 plus court costs of $86.25 for a total of $2,545.26.
Okay.
Same thing, getting the judgment is easy, getting the money is hard. Have you heard anything from him?
I haven't heard anything from him.
All right, this is the same piece of advice, maybe like a broken record. You sued him, you've just obtained a judgment. He has 30 days to pay it. If he doesn't pay, I want you to contact the court and we'll set up a discovery hearing.
Okay.
As far as you know, is he still at the Fawn River Road address?
To be honest, I don't know. I never went back.
I believe that's where he was served, so.
Yeah. It's his.
All right. 30 days, if he doesn't respond, you ask for a discovery subpoena.
Okay. Okay.
All right, you're good to go, thank you.
Thank you.
cleared the decks for our last case of the day, which is Rashad Clemens versus Walnut Meadows LLC. Rashad Clemens is here. I can't see you very well, Mr. Clemens. You have a light behind you and you're in shadow, but I can tell you that there. And Judy, would you take your last name? That's much better. Miss Judy, would you state your last name?
Shepherd.
And you're the manager at Walnut Meadows?
Yes.
This is a claim by Mr. Clemens for $1,120 for alleged failure to return his security deposit. Plaintiff counterclaimed, it's not clear in an amount, said stained carpet, carpet matted, smoked in the unit, carpet smelled. I hate when people smoke in the unit. I have what appears to be the notice from the security deposit, and we'll talk about that in a minute. Will you both please raise your right hand? Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes.
Yes.
Mr. Clemens, were you a tenant at Walnut Meadows? You put your hand down. And then you moved out? Is that correct?
Yes.
Mr. All right. And why do you believe they owe you $1,200? $1,120?
Because at one point in time, my rent was not 700, sir. It was 725 plus a 65 water bill.
All right. Well, Ms. Shepherd, do you agree the security deposit was $1,120?
No, his security deposit was $700.
Was a total of $100?
No, 700.
700. All right.
Yep.
All right, Mr. Clemens, why do you believe they owe you $1,120?
Because, Your Honor, my rent was $725. Then I moved into a new apartment, and then they started adding the water to our own bill. But before then, we was paying. I had to pay $725 plus her water bill, and I still believe I have money left on her ledger because I was paying extra money, Your Honor.
Now, the law says when you move, you have to pay, or you have to give your address in writing and turn in the keys. That triggers the security deposit law. So you apparently did that because they sent you the security deposit notice.
Yes, Your Honor.
And your carpet was damaged. Your refrigerator had a turkey in it. Things were dirty, and they did some things to clean the unit. So they sent you your security deposit notice back. And I indicate they claim that you smoked in there, but I can't say yay or nay. You had a water reimbursement fee of $35, and they replaced the carpet for $510. So that was a total of $545. They applied your security deposit of $700 and said balance due tenant $10. That math doesn't add up. 700 minus 545 isn't $10. They sent you $155, which does add up. That's the difference between 545 and 700. So they reimbursed you in February for $155 of your security deposit. Is that correct, Ms. Shepherd?
Yes. Yeah. He didn't smoke. His girlfriend did.
His girlfriend did?
Yeah.
Okay.
Mr. Clemens didn't smoke in the unit.
But other people did?
His living girlfriend did. And the carpet was stained. We had no choice but to replace it.
And it's a non-smoking unit?
All my properties are non-smoking. I didn't even charge him for the cost that we spent putting a coat of Kills on the walls to cover up the smoke smell so we could paint it and re-rent it.
All right, so you didn't smoke, but apparently someone that lived there did. And I hate when I rent a car or go into a hotel room that somebody smoked in it. So they had to do this to remediate it. So I'm still struggling on why you think they owe you $1,120. Mr. Clemens?
I was giving her extra money on my rent, Mr. Middleton.
Say that again.
I was instead of $725, I was actually giving her $800. I have my receipts to show for it, Mr. Middleton.
Well, she says that it's $700.
His rent was $725.
Oh, but you just said it wasn't $725.
I did not say it wasn't. No. Your deposit was $700. The rent was $725. We only raise our rent $25 a year when a tenant renews.
Down.
Whoops. All right, we're back. Thank you. All right, just a moment. Two, 642. Oh, that's this case. I don't have a landlord tenant case, but I can look up the lease. All right, so there was a lease. Mr. Clemens was not evicted or moved by a court action. He just decided to vacate.
Yes.
Okay.
And
And
because I
then,
knew he wanted to move, I didn't renew his lease. I let him go month to month.
all right, so it was month to month, and then he moved out. He gave you his address. You sent him, you put new carpeting, sent the security deposit notice.
Yep.
Which is what the law requires. So I still, after several times asking, don't understand why you think what you wrote. This property manager is trying to take my security deposit and use it for wear and tear. I don't believe the property better. I left the property better than most tenants have. So the security deposit is $700. It's not $1,120. They use the deposit to put new carpeting in the unit because your roommate smoked in it. Nothing else. Although they did do some painting and some repair, they didn't charge you for that. They then gave you $150, $55, which was the balance of your security deposit. There's some pictures here which show the carpet. Even whether it was stained or not, if someone was smoking in there, it needed to get replaced. So I find 0 for the plaintiff. I find that the landlord complied with the security deposit law. They sent you a notice. They applied the security deposit to an appropriate expense. They sent you the balance of the deposit, which was $155. So no cause for the plaintiff. Damages are 0. All right, Mr. Clemens, like I said, I find they complied with their obligations under the Landlord-Tenant Relationship Act, the security deposit law, and you get none. All right, we'll be in recess.
Thank you.
Thank you. Well, that was a bit herky-jerky too. I wish I'd had the lease, but there are photographs. They don't have smell-o-vision, but he also, I had some difficulty understanding him. But he didn't say anything that led me to believe he was entitled to $1,120. So in our live stream and our day,